Should I email IT? And is the power strip, it looks like it's plugged in. So good. Okay. All right. We have a couple things we need to discuss. I want to talk a little bit about Bruton. Mr. Trepanier, tell me the logistical situation you shared via email. You've got a witness who may be running a little late.
Yeah, I've got a witness. The GBI firearms analysis is actually stationed in Savannah, and she is on her way, but indicated that she may not be here before lunch.
Okay.
So that is the timing issue with respect to that witness.
You can have every other witness here before her, so that if that's going to be your last witness, that's going to be your last witness.
That's correct, Judge.
Okay. Anything else we need to talk about?
Co-counsel and I have been discussing the Bruton issue this morning. What we think is we may take a more conservative approach with it, and ask more just directly and if the court allows, lead a little bit with respect to Mr. Tolbert's statement, and instead of referring to another guy, just Mr. Tolbert indicated that he was at the location. Mr. Tolbert indicated he was there when Mr. Frank Fluid III was shot. So very briefly that way, without getting into other guy statements.
Okay, simply his conduct or presence there, and not, I guess it wouldn't be entirely what he observed, because it wouldn't be, and he saw someone else shoot, just he was there when Fluid got shot.
Yeah.
Okay.
Trying to be conservative with it that way instead of getting too much into the other guy sort of testimony.
Okay. All right. Ms. Feely, tell me your thoughts if that's the approach the state takes.
That's our preference.
Well, I'm sure it's your preference, but I guess I should be clearer. One option would be no testimony at all about anything Mr. Tolbert told law enforcement about the incident, unless he testifies, and then he can be impeached with that, or bolstered with it if he is impeached by another lawyer, et cetera. Another, at the other end of the spectrum, if that's the most conservative, would be the Simpkins. That's the Georgia Supreme Court case, Simpkins versus State at 303 Georgia 752. And then more recently, the U.S. Supreme Court case that Mr. Francis told us he doesn't approve of, Samia, S-A-M-I-A versus United States at 143 Supreme Court 2004, from just a couple months ago. Those, I believe, would allow what I thought the state's approach was going to be, which is the detective would say, Mr. Tolbert said that he and someone else were driving down North Side, and that someone else got out of the car and engaged with Fluid. That coupled with a limiting instruction, so it's not just that floating alone, but a limiting instruction that anything Detective Benton says, Tolbert said, could only be used against Tolbert and not against Mr. Williams. Under those two cases, that's sufficient. Now, Mr. Trepanier has charted a middle ground, which is, we're going to talk about Tolbert's statement, but it is Tolbert only. He was there, he was present for X and Y and Z. I don't think that requires a limiting instruction. I guess I don't mind saying anything you're hearing about what Tolbert said should be used only against Tolbert and not Williams. But I want to understand if that's the way the state goes, what objections, if any, you'll have, so I'm in a position to address them.
I agree. If there is no mention, if it's only Tolbert I don't think a limiting instruction would be appropriate either, but we'll see how the testimony comes out.
We will indeed. Okay. Mr. Francis, setting aside your disapproval of Samia and Simpkins and focusing on your client's situation, not Mr. Williams's situation, what's your reaction to Mr. Trepanier's latest version of how he's going to handle your client's statement?
I think that's proper under the current state of the law and would not require limiting instruction. However, I would need the court's guidance with respect to my limitations on cross-examination. So then that could I could sort of invite the need for a limiting instruction.
Got it.
I want to be careful not to run afoul of this court's judgment on this issue.
So my judgment is that it would be appropriate for Mr. Trepanier to have Detective Benton say, Mr. Tolbert told me he and someone else were driving. And in fact, Mr. Tolbert wasn't driving. I think that Simpkins and Samia allow that. I think that is legally complicated. I think in Georgia right now and with our current both two Supreme Courts, it's okay. I did read Justice Jackson's dissent, and like you said, they're right because they're final. And in 6 years, it could be that Samia is reversed because it's not reversing Bruton to say Samia went too far. But today, Samia and Simpkins are the law. And I say all that because I think you could, regardless of what Mr. Trepanier says, has Detective Benton say, you could ask Detective Benton, did my client say he was driving? No, he didn't say he was the driver. I think that's okay under the law, and I don't intend to limit you to the narrowness, and I understand the narrowness. It's a safe narrowness that the state wants to follow, but I think that you, in the same way that the state could, I don't think it's limited only to the state, could explore with Detective Benton that Mr. Tolbert said there was another, it wasn't just me there was someone else there. You can't go further than that, who was that person or anything like that, but that he wasn't the driver or he wasn't the one who got out of the car, that kind of thing, because I think that's consistent with Samia and Simpkins. If you go there, I do need to give a limiting instruction. And so it may well be that direct examination is done, and I don't say anything about direct examination. And if we continue with our order of business, Ms. Feely would do a cross-examination, and I don't need to say anything. But you may elect in your cross to explore areas that Mr. Trepanier could have, consistent with Samia and Simpkins, but did not. I think you'd have that ability as well. And frankly, Ms. Feely would also. I don't think she'd want to. But if you do, then I will be giving a limiting instruction. So I guess what I'd appreciate from you, and we may need to take a couple small breaks during Detective Benton's testimony, is to know before you start your cross if you think you are going to be more expansive in your exploration than the state was. Let me add one more thing, because if you are, I'm probably going to give the limiting instruction before you start and after you're done. Second thing I want to add, of course, Detective Benton can be made available to testify in your case in chief, should you put up evidence after your client testifies. If your client testifies in the way you forecast, Benton can come on in and we could just press play on his statement insofar as your client's credibility is attacked by some other lawyer in the courtroom.
Okay. I can say that I was writing down the questions that you proposed, and I like those questions. And I think that would keep us within the confines of the law. And it's so new, and we might be one of the first cases that are actually testing this. So I think those questions are sufficient, and they would elicit what I would be looking for anyway, and probably would not run afoul. But we still need a limiting instruction.
We would, if we're getting into the Simpkins space, then Simpkins, which actually is not so new, is about 5 years old now. Samia is new, and if the Simpkins court was wondering, what will the feds think? The answer is they're fine with Simpkins. But both those say you need to have a limiting instruction. What the essence of it is that if the co-defendant statement does not incriminate the defendant, so if Tolbert's statement doesn't incriminate Williams on its face, as in Williams was the guy driving the car, And it only becomes incriminating when linked with other evidence. Hey, Williams's cell phone was in the car. How do you explain the only two people who could drive the car were Ms. LaFleur and Mr. Williams, and Ms. LaFleur has testified, I was fast asleep. So there is other evidence that connects, but it wouldn't be Mr. Tolbert saying it was Williams. It's Mr. Tolbert saying I was with someone else. That set of facts and that approach, somewhat masked, is consistent, I believe, with Simpkins and Samia. That's exactly what happened in those two cases. But there's also the limiting instruction, which I'm happy to give. All right?
Right, so I don't anticipate my questions to go any further than the questions that you.
Okay. All right. So that's one thing we need to work through. Number two, juror 21, who really wanted to go to Florida, has come up with a new issue. That's Ms. Odie, and I believe her mother's here. Are you Ms. Odie's mother? Otay. All right, Ms. Otay, I need you to come on up to the podium, please. Right here. Good morning. Is your last name Otay?
It's Allen.
Can you spell your name, please?
My first and last.
First and last.
ANTIONETTE. Allen, ALLEN.
Ms. Allen, and you are Ms. Otay's mother?
I am.
Okay. And you're here and Ms. Otay is not. I need you to get in the record why your daughter is not here and you are.
Okay, so she's sick. She has COVID. We took a home test. And I heard that explanation. She wanted to go to Florida. They're already gone. That's over and done with.
Okay.
So that's not it. It actually, she wanted to be here, but she's not feeling well. She has been vomiting with coughing. So she has some symptoms.
Okay. I know you interact with my staff a little bit about some kind of evidence that she's not in Florida. She's sick. She tried to go to the doctor, but it wasn't real clear.
So we did try to go to Northside Hospital, still have the wristband and everything.
And when was this?
It was last night.
Okay.
Still have her wristband as well. The waiting, they advised her to either she stay or there would be a 7 to 8 hour wait. I am more than happy to go and take her if you need more physical evidence, but we did sign to leave. We didn't want to stay 7 to 8 hours at
Okay.
Northside Hospital.
Is there any evidence showing that she went to Northside?
The wristband, and you can actually, I got it.
Okay. If you can give the wristband to Deputy Gordon, please. Okay, I guess it doesn't really tell us when Ms. Otay,
You can actually
When-
call.
well, I'm not going to do any calling.
okay.
But what Ms. Otay is going to need to do,
Okay.
if she wants to not get pretty sideways with the justice system,
Gotcha.
would be to provide written documentation, some form of proof that she went to the hospital,
Mhm.
that she's unable to be here now.
Okay.
So not just a handwritten note from mom, and I know you're not suggesting that, but medical something with dates on it. So that little printed strip has your daughter's name on it, but it doesn't tell me when it was generated. I don't know if that's from last week or
Gotcha.
whenever.
I can definitely call.
And I'm pushing back, not because I'm unsympathetic to folks who are not well. I want your daughter to be healthy. She seemed pretty anxious to be in Florida for her niece's birthday. And so this is a strange coincidence
It is. And I
because
agree.
let me finish.
agree.
She seemed 100% okay at 5:15 yesterday.
Gotcha.
And so it's unfortunate if she's taken ill, but those two scenarios don't line up in a real convincing way.
I got you. I truly understand. The party that was gone, they left last night. So she's here.
Well-
She, if I need to bring her, I can bring her.
No, if she's
Oh.
not well, I don't want her to come in. But it would be helpful, if, well, I'm going to let you and your daughter think about how she's going to
Sure.
provide sufficient proof that she's in Georgia right now
Okay.
and that she's not well, because her calling me right now wouldn't tell me where she is.
Definitely.
Um,
So how would I communicate with the court to prove that she's still here and show the proof?
is she, I don't know her living situation. Does she stay with you?
She stays with me.
So she's at home right now with you? I mean, she's at your house right now.
That is correct.
Okay. And is that a house or an apartment?
It's an apartment.
So I'm going to give you a business card for, does Ms. Nelson have business cards right there? Great. For someone on my staff. Does it have the email address on it? I need you to email to that email address, a photograph of you with your daughter holding up that jury summons.
Okay,
Okay?
all right,
And I need that this morning.
okay,
And we'll need some medical documentation that she's not doing well. And doctor, it may be that she just has the flu, and I hope that's what she's got. So I understand it's not necessarily going to be, here's proof that she had laryngitis or something like that.
gotcha.
But
So would the, because I asked for paperwork at Northside, of course, because that they all said someone could call and verify that she did come in. If I'm able to bring, get
yes,
for that
you
last
need
night.
them to commit to paper that that wristband is from you, and more importantly, your daughter being at Northside this morning, last night, whenever it was.
Okay.
All right.
No problem.
So just so we're clear, if we don't get that photograph before lunch today,
Mhm.
then I'm going to issue an order that
Oh.
holds your daughter in contempt. She'll need to come to court when she's healthy, and we'll work through what the consequences of that would be.
Okay, so you're saying if you don't get it, what, how will I know if everything is clear once I get there, I'm taking a picture to send that, then I'm
Yeah.
working on the actual documentation. with
So
Northside.
we'll let you know that the photo was received, and if the photo was received with the two of you holding up that jury summons,
Mhm.
then we can take a deep breath, because we know she's not in Florida,
Gotcha,
but she's also not here. And then we don't have to worry about the noon deadline, but you and your daughter need to get documentation that she was medically unable to be here.
gotcha.
Okay?
No worries, thank you so much.
All right. Thank you.
All right, can I go out this way? Okay. Thank you.
So we are down to 12 jurors. Mr. Trepanier, anything you want to get on the record in connection with that?
No, Judge.
Ms. Feely? Mr. Francis? Okay. Anything else, Mr. Trepanier, before we bring the jurors in?
I just have 1 minute to go speak with Detective Benton before,
Is she the next witness?
yeah, she'll be the next witness.
Definitely. Don't go yet. Let's just see if there's anything else going on. But I think it's helpful to let her know the way the three lawyers may be approaching the Tolbert statement piece of this. And I will always entertain objections, but if Mr. Trepanier is being a little guiding in his questions about Detective Benton's conversation with Mr. Tolbert, I'm probably not going to find that as leading. If it gets to be egregiously so, I mean, you do what you need to do, defense counsel, but I think it's safe. and thus wise for that to be more structured than other inquiries that the state may have of Detective Benton. Ms. Feely, anything else before the jurors come in? Mr. Francis? All right, so have that quick chat. When I see you come back in, we'll get the jurors in.
Thank you, Judge.
Pardon me? Yeah. Yeah. No, I had noticed that too. Like, how would that have worked out? What you shaking your head for already? It's only 9:30.
Kids.
Kids. Yeah, I declared back there, no jurors under 25 anymore. Then someone on my team said, wait, my daughter is 23 and she'd be a great juror. Like, fair enough. They are responsible. Miss Sadness never came back to get her hours in court. I got fussed at for being too nice to her. I just wanted her out of here. So we're waiting for the sit. We're back on the record. I think so that I don't draw attention to one line of questioning versus the other. If you're pretty sure you're going to ask a few of those questions, Mr. Francis, what I'll probably do before the detective starts her testimony is say that you may hear from Detective Benton about statements Mr. Tolbert made. Those are to be used only, any evidence of that, if any, should be used only against Mr. Tolbert. So I'm not drawing attention just to Mr. Francis's piece. I have to give a limiting instruction if he's going to explore what he's entitled to, I believe, under the law. I'm happy to give it real close in time, contemporaneously, not with each question, but just before Mr. Francis starts. But as I was thinking about it, maybe at the beginning and the end of her testimony, is when I do that. Do you have a perspective on that, Mr. Trepanier?
No, Judge, I think that's well within the court's discretion.
Okay, it is. I appreciate that.
I don't have a perspective. I don't have a strong opinion one way or the other. We should proceed with respect to the order of the limiting instruction.
Okay, Ms. Feely, I'm more focused on your thoughts about where you want. You may want it right before Mr. Francis goes and right after, but that just is going to emphasize, hey, folks, something is coming up, and I'm open to either.
I think we definitely want it after. I think that would be sufficient.
Just after his Mr. Francis's cross-examination is up. I'd like to do it before as well, but that's why I was saying, let's just do it at the beginning of her testimony. But that in some ways could get a little remote because this would be the third line of questioning. I mean, it could be a couple hours in. So I'm open to doing it. It's actually going to happen 3 times because it will be in the final charge as well. I don't know that it is right now. I'm going to need to add it, but but it may not be in the final charge because it really depends on what Mr. Tolbert decides to do. But I certainly need to do it before that decision is made. So your preference, certainly after. I'm hearing you say after. I could leave it at just that, if that's your preference.
I'm emailing with the health section, and I think we need to have it before as well.
Okay, before Mr. Francis starts. Okay, we'll do it that way. I'm good. Let's bring the jurors in, please. Hey there.
President of the California.
Thank you, Deputy Gordon. You're welcome. Be seated. Hold on one second. What's it saying to you? What did you do? You messed like with the cable too. Was the cable maybe loose in the back?
Oh, that's
It's hard to get good help these days. Which side, when you're facing the back, is it? Okay, no, he was pressing the same button. Okay. Yeah. No, we all know where it is. Maybe we're just not holding it in long enough. Okay. All right. Thank you, sir. Good morning.
Good morning.
Thank you all for being here. If any of you are good counters, you may notice we're down to 12. We have 12 jurors. Juror 21 isn't here anymore. Her mother came instead saying that she wasn't feeling well and couldn't be here. That's not how it's supposed to work. And I'm getting proof that, in fact, juror 21 is still in Georgia and not down in Florida at her niece's birthday party where she wanted to go. And that I hope she's okay, but that there is some illness that is making it hard for her to be here. But that's one of the things we had to work through this morning. So I apologize for the delay. I need you all to stay healthy, to not go to Florida, and to stay focused on being a juror. So we are still in the midst of the state's case. The forecast yesterday was that the next witness would be long. So we'll see how that goes. And I'll ask Mr. Trepanier to call the state's next witness.
State calls Detective Summer Benton.
You swear affirm that the testimony you will give is the truth, the whole truth, and nothing but the truth so help you God. Please let me have a seat. Say and spell your name, right?
Detective Summer R. Benton, SUNNER. No initials are.
Good morning, Detective Benton. Where are you currently employed?
City of Atlanta Police Department
How long have you been employed there?
since December of 2001, almost 20.
And what role are you currently employed there?
I'm a homicide detective.
Are you post-certified?
Yes, ma'am.
And
Just
just
pause for 1 second. Can your microphone is off. If you put your finger in that little dip by the red light and then take it off. Perfect.
Okay.
Thank you.
What is it? So one, are you post-certified?
Yes,
Okay. What does it mean to be post-certified?
it means you're certified by the state of Georgia. You have arrest powers and you're able to perform duties as a police officer or as a deputy.
How long have you been a homicide detective?
Oh, over 14 years.
And prior to being a homicide detective, what were your roles at the City of Atlanta Police Department?
Came out of the academy. I was a bicycle cop. Rode a bicycle around for about a year, then went undercover where I did federal firearms, buying illegal guns, vice, narcotics. Went back to the zone, handled 911 calls, was a regular beat officer. Then made my way to take the test for the investigator's test, became a detective, went back to narcotics, then went to major crimes, and eventually in 2009 made it to homicide.
Approximately how many homicide cases have you investigated as a lead detective?
I'd say over 150.
What does it mean to be a lead detective on a homicide case?
So a lead detective means this is your case from start to finish. You get called in on the night that it happens, and you are investigating this case all the way through until it is completed, or you are either promoted or transferred out of homicide, and then it gets reassigned. So your job basically is follow the evidence and complete the case.
So you oversee all the aspects of an investigation.
That's correct.
And is there a typical process that you follow in investigation, or it depends on the situation?
Every case is different. So you don't assume anything. When you get the call, you get to the scene. Depending on what the scene looks like, depending on the evidence that you get, that's what's going to take you through to your next steps of the investigation.
And obviously, does the investigation change based on what types of evidence or information you develop?
Yes, it does.
What about, have you assisted as a homicide detective?
On hundreds of cases.
Okay. And when you assist as a homicide detective, what does that mean?
So we're on a rotation, a unit rotation. So everybody's on a list. And so if you're at the top of the list, the next case is yours. It doesn't matter what time it comes up or what day it comes up, that's your case. So if it happens on day watch, all of day watch homicide detectives will go out to the scene and they will assist whoever the lead detective is, whether it's drawing the crime scene, processing some of the evidence with the crime scene techs, doing a door-to-door canvas, interviewing witnesses, whatever the lead detective needs, pulling video surveillance, that's us assisting that lead detective on what they need.
And if you are that person that's up, are you what would some people refer to as on call?
Yes,
Okay. Do you work a normal shift schedule though?
yes. So my shift consists currently is day watch hours. So I work 4 10s, so from approximately 7 or 8 a.m. till 5 or 6 p.m.
And when you're on call or next up, you take the case no matter when the call or assignment comes in?
That's correct.
Okay. Is it your job when you're on call to immediately respond, and I'm going to use the word, take over the scene and investigation?
Yes, it is.
And we talked about assisting, but do you rely on other homicide investigators for certain tasks on cases?
Absolutely.
Why do you do that?
Some homicide detectives, they have expertise in areas that I don't have expertise in, and I may know more knowledge about something that they don't know. So each one has their niche in homicide. So there's going to be things where I'm going to reach out to another detective because I know that they're very good at that, and ask them to assist me.
So those individuals, homicide detectives may have specialized training or experience that sometimes is relied on by other investigators.
That's correct.
Okay. Do you have a specific type of case where if you're not the lead on call that gets it, that you are likely to be called in on to assist?
Yes, I'm now one of the most veteran homicide detectives in Atlanta Police. So I'm on what they call the cold complex case squad, where if a case is extremely high profile, or it's going to be extremely complex, where there's going to be multiple shooters, or it's already connected to multiple other crimes, they bring me and a couple of the other detectives in, and we take over not just the homicide case, but we'll take over the ag assault to the property. We'll take it all and bring it in as one. I also work almost exclusively all child deaths. So I work all those homicides as well.
On January 14th of 2019, were you on call?
Yes, I was.
Did you receive notice that you were needed on an investigation?
Yes, I did.
Okay. How do you receive that notice?
Detective Bacon, who at the time was on our Warren Watch Major Crimes unit, he contacted me approximately 4:47 in the morning, called me on my city cell and advised me that I had a case and I needed to wake up and get to the scene.
Do you remember, and I think you answered this, but what time you received that call? Is that 4:47?
Yes.
Okay. What time do you remember arriving on the scene?
05:59 hours is what time I arrived.
So 05:59 is at 5:59 a.m.?
Yes, sorry.
When you go to a scene, when you're on call, are you driving a personal vehicle or a business vehicle?
Hopefully you're driving a business vehicle. Majority of the time you're driving a city car. If you're the top 5 right now, top 5 in the rotation, you're handed a take home car.
Is there a safety or a practical reason for that?
In case anything happens, because once you get the phone call, you're immediately considered on duty. So then because you're on duty, they want you to be in a city car.
On January 14th of 2019, what location or address did you respond to?
567 Northside Drive here in Atlanta, Fulton County.
And was it 567 or 576?
576, I apologize.
Okay. And you mentioned, is that location in Fulton County?
Yes, it is.
Okay. So when you arrive, what does the scene look like?
So when I arrived, part of Northside Drive had been blocked off by both patrol vehicles with their blue lights and also yellow crime scene tape. So when I got there, I sat in the car for a minute, just getting my bearings. And then when I got out of the car is when I saw Sergeant Bart Miller.
Okay. And you mentioned traffic being blocked off. Which direction of travel do you remember?
I believe it was southbound traffic was
Okay.
blocked off.
So southbound traffic on Northside Drive Northwest.
Yes,
Okay. Would that be the direction headed towards North Avenue?
yes.
And I'm going to show opposing counsel what's been marked as State's Exhibit 98.
I pressed something here for muted or unmuted. Okay,
Do you recognize what State's Exhibit 98 is?
yes, it's a Google map of the area.
And would using that map help describe your testimony in this case?
Sure.
All right. Your Honor, at this time, the state would tender it out of this State's Exhibit 98.
Any objection to States 98, Ms. Feely? Mr. Francis?
No, Your Honor.
Admitted.
So we're looking. That should be larger. So looking at State's Exhibit 98, can you point out, I'm not sure if your screen will allow you, but can you?
So it is a touch screen. If you'll tap the screen once, a little pencil icon will appear in the lower left. So tap screen anywhere, tap that little pencil icon. And now your finger will draw, I think it'll be in red, but so whatever the questions are, you can try to illustrate on the screen.
So on this map, are you able to generally see where you would have responded to 576 Northside Drive Northwest?
Yes, it would have been right around, oh, was this, I mean, this area here is, I believe.
Okay.
I'm looking at it correctly.
All right. So the area north of there is the intersection of Northside Drive Northwest and Donald Lee Hollowell.
That's correct.
Okay. And then just south of there would be the intersection of Northside Drive Northwest and North Ave. Is that
Correct.
correct? Okay. And so it was the southbound lane of traffic, that direction that was blocked off.
Yes.
All right. When you arrive, has the scene been secured by the Atlanta Police Department?
Yes, it has.
So what does it mean for a scene to be secured?
Basically, the scene is taped off and is being protected so that there's no vehicular traffic coming in and out of the scene. There's no pedestrian traffic coming in and out of the scene. And they try to keep it as when the incident happened, as close to as when the incident happened as possible.
And what's the purpose of keeping it as close to the incident, as possible when you
Not
were-
contaminate the scene, to not have people coming in and out. Granted, EMS, of course, life-saving measures always trump crime scene. But just to keep everything as pristine as when the incident happened for evidence purposes.
At the point that you arrived at that location, were you aware of the status of the victim in this case?
Yes, he was deceased, I believe, when they called me.
Okay. What sort of injury did you understand that he had sustained?
A gunshot wound to the leg.
At this point in the investigation, did you have an identification of the victim?
Not until I arrived on scene.
Okay. Is that uncommon at the initial stages of your investigation, that you may respond and not know who a victim is?
No,
Ultimately, were you able to identify who the victim was in this case?
yes,
Okay, and who did you identify as the victim in this case?
Frank Fluet III.
So now we know that you've arrived at the scene. Let's talk generally about how you evaluate a crime scene and document and collect evidence. So do you do an initial walkthrough of a scene?
I do.
Okay. And kind of what's the purpose of that initial walkthrough for you?
The initial walkthrough basically is telling me, I'm identifying pieces of evidentiary value. Also reading the scene, seeing what the scene tells me as to if the evidence is telling me what may have happened during the incident. And so I also want to, when I'm doing the walkthrough, I'm identifying what I want my crime scene to process, how to photograph it, because I'm a little particular about that, and what evidence I want taken back and what tests I want done on specific evidence.
Okay. So you're looking for items of evidentiary value.
That's correct.
Do you often identify items and then realize they may not have evidentiary value, or vice versa? Like, how does that work?
I'd rather take everything and not need it than not take something and need it.
Okay.
So I'm going to take as much as I can.
And then are you, we talk about the walkthrough and what's actually at the scene. Are you also looking around?
Yes,
Okay. And what are you looking around for?
I'm looking around for cameras, seeing if there's any video surveillance in the area. Even not necessarily this scene, but even on other scenes, you're looking around to see, are there apartments that have balconies that face that area for potential ear witnesses? People may have been standing outside, eyewitnesses to do canvases on, but mainly I'm looking for video surveillance.
And do you document a crime scene?
Absolutely.
Okay. What is the purpose of that?
The photographs are to document the crime scene as is. The crime scene sketch is to, in case we need to go back and do any type of reenactment, or we need to put the crime scene back together, we'll do a sketch.
And with respect to photographs, who takes those photographs?
The crime scene technician.
Are there generally like multiple passes of photos over a crime scene?
There's 2 passes. So the first pass is the crime scene as is. The second pass is with evidence markers. So once they put all the evidence markers back, they'll then go back and re-photograph the entire crime scene.
Okay. And you mentioned an evidence marker. What's an evidence marker?
It's like a little yellow stand, or we have them in white too, I think, and they have numbers on them, and they put them down to identify pieces of evidence.
Okay. You mentioned you put them down to identify pieces of evidence. Do the numbers mean anything to you?
They do to me.
Okay. So how do you use the numbers?
So I usually start where the person was or where the body is. That's always number 1. And then I go out from that point, and it's normally clockwise. That way I can sit there and be able to tell a story as to this is here, and then I'm not going to get mixed up. So that's how all the numbers are going to be.
Okay. And you mentioned a crime scene technician. What is a crime scene technician?
A crime scene technician is a civilian position within the Atlanta Police Department, and it's someone who has gone through multiple hours of training on how to process specific crime scenes or all crime scenes. And they assist us in all of our crime scenes, whether it's burglaries, robberies, vehicle larcenies, homicides, ag assaults.
And what's their role and responsibility?
Their role is to photograph and collect evidence.
Do you oversee how crime scene techs document the crime scene on your cases?
Always.
Okay. Do you tell them where to place the evidence markers and what to photograph?
Yes.
Okay. Is there a specific way that evidence is collected?
Yes. So when they go down to collect the evidence, first they make sure that we're ready for the evidence to be picked up. And sometimes if the medical examiner needs to come, we'll wait for the medical examiner to get there so they can do their photographs. And once everything is ready, if it's a shell casing, they'll pick the shell casing up, of course, with gloves, but they'll write down the date and the time that they are collecting that one piece of evidence, and it'll go on the outside of the bag. They will then bag that piece of evidence and seal it. If it's a swab, there's a little box where the little cotton swab comes out of. They'll write on the outside of the box, this is evidence marker, whatever number it is, this is the date and this is the time that this swab was collected.
Do each of those things that you're trying, are there different sort of containers for different sorts of evidence?
Yes.
Okay. I guess, can you give us just, an example, give the jury an example of what type of, container would be used for different types of evidence in general?
Sure. So if there's a firearm on scene, we have firearm boxes that we put together and we built those. If it's a shell casing, we have very small envelopes that the shell casings will go in. If it's clothing, we have paper bags. Everything always goes in paper, not in plastic, because plastic will make the evidence sweat and it'll degrade the DNA. That's why everything's always in paper. And if it's a swab, cotton swabs, it's like a long, thin, you could put a pen in it type of box, like an ink pen, and that's where a swab would go.
So I'm going to now move kind of to this case in particular, now that we're done with this general overview. So did you conduct an initial walkthrough at 576 Northside Drive Northwest?
Yes.
All right. Do you remember what items of evidence or things of evidentiary value that you saw?
Yes, when we did the initial walkthrough, we put the evidence markers down. After we put the evidence markers down is when we located 2 more pieces of evidence. So those, of course, we don't change the markers once they're put down. We then just add those. There were 2 shell casings, 45 caliber, 1 live round was also a 45 caliber. I believe to pick up a lighter, and we've swabbed some blood.
And
shoes.
some shoes. In this case, was there a crime scene tech on the scene working with you to document everything?
Yes.
Okay. And was the scene documented by photograph?
Yes, it was.
All right. And did you direct the crime scene tech to place the evidence markers and photograph the scene that's like in that second pass as well?
Yes, I did.
Okay. I'm showing the opposing counsel what I've previously marked as states exhibits 6 through 45. Take a minute, just look through what I marked as 6 through 45. And when you've had a chance to look through those, all right, have you had a chance to review states exhibits 6 through 45?
Yes.
All right, do you recognize those?
Yes, I do.
Okay, how do you recognize those?
These are the photographs of the crime scene at 576 Northside Drive.
Okay, and are those a fair and accurate depiction of the photographs that were taken on January 14th, 29?
Yes.
Your Honor, at this time, the state tenders states exhibits 6 through 45 into evidence.
Mr. Francis, any objections?
Objection, John.
Ms. Feely? Admitted.
All right, so looking at, and we're just going to go through these one by one. So this is, and make sure that we're looking at the same thing as I share it with you.
When you say one by one, we're going to look at all 40 pictures, or
But
you're,
I'm just going to briefly go through them, Judge.
Okay.
So is this states exhibit 6?
Yes, it is.
All right. And is this an overview of the crime scene?
Yes, it is.
Okay, on the first pass?
Yes.
This exhibit, is this state's exhibit?
so you can state for the record which exhibit it is, because it's in the record, and then ask questions about whatever that is.
State's exhibit 9?
Yes.
Okay. Why is this photo taken?
Because the address, we needed to mark the exact location of the incident.
State's Exhibit 10, what's this?
That's not the same one I have. Go back one. Nope. Mm-mm. Yes,
Okay, so State's Exhibit 10, what is this?
this is an overview of the crime scene. They're in the southbound lanes, but they're taking the photograph northbound.
Okay. And just looking at this first set of photographs, are those photographs of before you put the evidence markers down?
That's correct.
Okay. All right. So on the second pass, do you see the exhibit that begins with the second pass that matches this?
Yes, I do.
Okay. And just so that the record's clear, what exhibit is that?
This is the second pass of the crime scene. It is the southbound lanes, but they're taking a photograph northbound, but now you have all the evidence markers out.
Okay. And is this photo from the other direction?
Yes, it is.
Okay. Do you take layers of photos? So one like just different distances?
Yes, so crime scene, what they do is they take 3 types of photographs. They take one overall, one mid-range, and one aerial. So it's right on top of the evidence.
Okay. So evidence marker 1, what is evidence marker 1?
It's a 45 caliber shell casing.
Okay. And when you are on a crime scene and you see a shell casing, what does that indicate to you?
A shooting, a weapon was fired.
Now looking at what's been evidence marker 2, what is marked with evidence marker 2?
It is a live 45 caliber cartridge.
Okay, so you see it's a live cartridge. So what does that mean?
It's a live round, so it's ready to be fired if it was placed into a weapon.
Why would there be a live round on a crime scene?
Most likely because the firearm jammed and they probably had to rack around out of the chamber before they fired again.
Do you have experience with firearms?
Oh, yes.
As part of your training as a law enforcement officer, do you qualify with firearms?
Every year.
Okay. What sort of firearm do you qualify with?
I qualify with a Glock 9mm, but in previous years, we've qualified with 40s and other types of 9s.
Okay. And are you familiar with the difference between like a revolver and a semi-automatic firearm?
Yes.
Okay. So for there to be shell casings and live rounds, what does that indicate to you?
It had to be a semi-automatic firearm.
Okay.
Bless you.
And when you talk about there must have been a jam or something like that, what does that mean?
A lot of times, because semi-automatic firearms, granted, they so when you have the firearm and you have the magazine, as it's firing, the magazine is pushing up another one. Sometimes, depending on the firearm, the make, how you hold it, anything like that, it can get stovepiped, which means a live round will get stuck in the chamber and it's not going to fire. So you literally have to force it out by racking the top slide back, forcing it out. And then once it closes back, another round will chamber into and be ready to fire.
Now we're looking at evidence marker 3. What is that?
And that's a second 45 caliber shell casing.
Okay. So how many shell casings and live rounds did you see?
I saw 2 shell casings and there was 1 live round.
If there are 2 shell casings, what does that indicate to you?
The gun was fired twice.
I'm showing opposing counsel what I've marked as State's Exhibit 88. Looking at State's Exhibit 88, do you recognize that?
Yes, I do.
Okay, how do you recognize that?
This is the bag that our crime scene technician filled out, bless you. When they placed the 245 automatic cartridge casings in the bag.
And how do you recognize that?
It was done on scene.
Okay. Is there a way that you know that specific bag is the one from your scene versus somewhere else?
Yes, so if you actually look at everything we have, you have to be able to put all of this on there. So I'm about to apologize to a microphone. You have the Atlanta Police Department, who the victim is, the date of the crime, the actual case number. And then it'll tell you right here, there's 1 live round and 2 shell casings, all 45 calibers that are on top, that are on the bag. And then it's sealed.
Your Honor, this time the state tenders State's Exhibit 88.
Mr. Francis, any objection to 88?
No objection.
Ms. Feely?
No.
Admitted?
All right. We're now looking at evidence marker 4. What is evidence marker 4?
It's a knife.
Okay. And seeing that knife on that scene, did that indicate anything to you?
Possibly somebody had the knife that may have been some type of confrontation.
Okay. States, we're looking at evidence marker 5 in this photo. What is evidence marker 5?
That's a type of cap or headwear.
Okay. Evidence marker 6.
Those are Mr. Fluette's shoes.
And you said they're Mr. Fluid shoes. How did you come to that conclusion?
Video surveillance.
Does the fact that his shoes were off indicate anything to you?
No, it could be 2 things. One, they came off during a struggle, or Grady EMS pulled him off when they were trying to save his life.
Have you seen Grady EMS pull articles of clothing off in the past?
Pull, tear, cut to save somebody's life, they'll do anything. And they're very good at it.
All right, now we're looking at evidence marker number 7. Did you recognize that?
Yes, it was on the crime scene, sort of in the middle of the crime scene, so we decided to mark it.
Okay. And evidence marker 8, what is that?
I'm having trouble seeing it. I apologize. I believe that is a diamond earring.
Okay. You mentioned there were some items on the scene that you originally didn't see. Was evidence marker 8 one of those items?
Yes, it was.
Okay. What did evidence marker 8 indicate to you?
There was definitely an altercation. Evidence marker 8 there appeared to have been pulled out of an ear.
Were you able to connect evidence marker 8 with anybody?
Mr. Fluette,
Okay. And how did you do that?
through the family.
Okay. Showing opposing counsel what I've marked as State's Exhibit 89. What is, do you recognize State's Exhibit 89?
I do.
And how do you recognize it?
Based off the bag, again, it is filled out. And then there's also an evidence marker on this side. And it tells you exactly what it is, the date and time that it was collected, where it was collected from.
Your Honor, at this time, the state would tender State's Exhibit 89.
Mr. Francis, any objection to 89? Ms. Feely? Admitted.
Would you mind opening State's Exhibit 89 and showing the jury?
I don't know if everybody can see this. This is the backing or the front part that holds the gemstone. And there's the actual gemstone.
All right, now I'm showing you the last two photos. What are these photos of?
Surveillance camera.
Okay, and where was that surveillance camera located?
This is located at the incident location right there on the building at 576 Northside Drive.
So you see that video camera and what do?
I get a little excited. I immediately contact or wait until regular business hours and I contact, try to figure out who owns the building, contact management. Therefore I did. And that's when I learned that the cameras were not in working order.
So you were unable to obtain any sort of surveillance from that camera?
That particular camera, no, I was not.
Let's go back just briefly about the items of evidence. So after they're collected, those were collected at your instruction, is that right?
They were.
All right. So where do those items go after they're collected?
Different places. So swabs will be taken down to the Georgia Bureau of Investigation for DNA processing or serology processing. Shell casings, we actually have our own ballistics lab with the Atlanta Police Department. And depending on whether they're swabbed or printed beforehand, our crime scene technicians will do that. But then they'll be taken straight to the ballistics lab to be test fired, or if it's a shell casing, it'll be placed into the NIBIN system, which is the National Ballistics Database System, to see if it matches any other crime scenes.
Is evidence stored in a secure place?
Yeah, oh yes.
Okay. Can anyone just walk in and have access to items?
No,
Are you able to just walk in and have access to items?
no.
Okay. So is there a process for making sure that items are not, tampered with?
Yes, you have to, there's very few and very specific people that have access to evidence. You have to make an appointment if you want to take the evidence. So when you go down there, you have to speak to a supervisor, advise them this is why you're taking the evidence. You have to then sign the evidence out. It's then placed on a paper format and a digital format. Just paper as backup. And then you still don't go back. They bring the evidence to you. So you're never going back to where it is unless for a very specific reason.
Now that we've looked at the photographs and some of that physical evidence, do you try to locate witnesses?
Yes,
Okay. And do you try to get an initial understanding of what happened?
yes.
All right. Were there any on-scene witnesses that you spoke with?
I spoke with one female security officer who heard the shot but didn't see anything. And then I called a second witness who stayed on scene, but then they did have to get to work, but I was able to call him and speak with him that morning and also face-to-face at a later date.
And when you say miss, I think the first individual you mentioned she didn't see the shooting itself.
That's what she stated.
Okay. The other individual, do you remember who that was?
Brian Wiley?
Okay. Do you remember what Mr. Wiley recounted to you had occurred that day?
Yes.
Do Was he able to give a description of a possible suspect vehicle?
Yes,
Okay. What was that description?
a small grayish SUV, possibly in a Suzu.
Okay. What type of vehicle is that? Like, how would you describe that?
A very small boxy SUV.
Was he able to tell you how many people were involved?
2. Victim and person they were fighting with, and he stated there was a driver and a passenger of that vehicle.
So he indicated there was a driver and a passenger of the boxy SUV.
That's correct.
Okay. And then there was Mr. Fluid.
That's correct.
Okay. As a homicide detective, we mentioned the surveillance videos and other types of recordings. Were you able to obtain video footage relevant or related to the death of Mr. Fluid?
Yes, Georgia Tech actually had a camera on the corner, a little bit north of the crime scene, and we were able to get video footage from that.
All right, so I'm going to publish for you. This is Exhibit 4. Is this the Georgia Tech video that you viewed on this case?
Yes, it is.
Okay, so I'm gonna hit play, and tell me as you're watching this the things that stick out to you.
Okay.
And I'll pause the video at different timestamps.
That's Mr. Fluet that's walking down the street.
Okay.
And as you can see, he's carrying a backpack.
Okay. So he's carrying a backpack. Was there a backpack on your crime scene?
No, there was not.
Was there did you try to find out if there was a backpack anywhere?
Yes, I called down to the detectives that were at Grady Hospital with Mr. Fluet and asked if a backpack had been brought in with him, and I was told no.
So as far as you are aware, the backpack that he had was gone.
That's correct.
Okay. So as this is playing, what direction is Mr. Fluet walking?
He's walking southbound of Northside Drive. If Mercedes-Benz Stadium had been built at the time, he's walking in the direction of Mercedes-Benz Stadium.
And looking at this video as we continue to see Mr. Fluet walking, where was the crime scene in relation to, the footage on this video?
You guys see the pole that's masking part of the video? Behind that.
So, I mean, knowing that, did that make your job a little bit more difficult?
Yes, but
Okay. Would you have preferred that you would have been able to see things a little more clearly?
absolutely.
Okay. And the time that Mr. Fluid is walking down the street, that's approximately 3:34 in the morning?
Yes, sir.
Now, watching this video, were you able to eventually see a vehicle that matched the description of what Mr. Wiley gave?
Yes.
Did that vehicle just appear?
Yes, it did.
Okay. So again, I'm going to hit play. So what does that vehicle do? What do you see it doing?
This vehicle pulls into a driveway and then does like a turnaround in this area. It'll stop and sort of pull back out.
Do you remember what was at that driveway?
I believe it was a, some type of warehouse.
Was that warehouse open at that time?
No, it was not. The vehicle is actually stopped at this point, and how we can tell is based off the shadows and the fact that the lights are not moving on the other side of the pole.
And that was going to be my question is, how do we know that the vehicle stays there instead of going somewhere else?
Because you can based off the shadow on the right side where it is, and the lights are not moving on the left side of the pole. And eventually you'll see this car back out and do a U-turn.
Okay. And so at this point, it's about 3:35 a.m., 3:36 a.m.
Based off of Georgia Tech's cameras, yes.
Do you sometimes see that cameras may have a slight difference in timings?
Yeah, sometimes they're a couple minutes off. Sometimes gas station video, it just hasn't changed over from daylight savings time. Every camera is different. So you have to base that camera off of, okay, what's the time right now based off of your watch or your phone or whatever, and compare it to what's saying now.
And I've paused it at 3:36 a.m. and 18 seconds. In that top left corner, what do you see there?
It's Mr. Wiley's vehicle.
Okay. And what does Mr. Wiley's vehicle do?
It does a U-turn and stops right behind the pole, maybe for a few seconds, and then you see it do another U-turn and start to slowly move northbound on the North Side Drive.
And was that consistent with what Mr. Wiley told you?
Yes, it was.
Okay. So I'm just pausing it again at 3 a.m., 3:37 a.m. and 3 seconds. Did a vehicle just back up into that warehouse driveway that you mentioned?
Yes, so that's
Okay.
the same vehicle that you guys saw earlier, pull southbound on Northside Drive, pull into that same driveway and do a U-turn. This is the same vehicle. It just backs up and then you're going to see it pull out and travel north on Northside Drive.
And I'm playing the video again for the record. I'm pausing at 3 a.m., 3:37 a.m. and 24 seconds. So was there anything else in this Georgia Tech video that you thought was relevant to the investigation?
No.
Okay. Now, was this the first video that you obtained as part of your investigation?
Yes, it is.
Okay. So having seen this portion of the video, kind of what's your next step?
So I contacted the Video Integration Center, which is what we call our VIC units, and that is the department or the unit that controls the cameras that you see all around Atlanta. And I asked if they could look in this area, one, to see if we had any cameras, Atlanta Police had any cameras in the area, or we had partnered with a company that may have cameras that we have access to in the area, to see if they could identify the vehicle and if we have any license plate readers in the area. So we could try to see, one, if that's the vehicle that matches this video, what is the license plate to that vehicle?
Were you able to obtain VIC video?
Yes, I was.
All right. So, I'm going to publish State's Exhibit 5.
Okay. 5? That's body cam footage. 47?
$47, Your Honor.
Okay. You can publish whatever you want, just.
No, I just,
if
thank
it's
you for the
been-
clarification, Judge. Yes, so publishing 47. All right, so is this Mr. Fluid?
No,
Okay, so I just want to be clear. So what timestamp do you remember what timestamp where you were able to kind of first see Mr. Fluid in this case?
I believe it was prior to 3:30.
Okay,
I want to say it was like 3:28, maybe, I don't know.
so let's go to 3:28. And we're just gonna play it from 3:28. And that's marked as 3:28 a.m.
That's correct.
Okay.
And this is actually Donnelly Hollowell Parkway.
Okay.
And the cross street there is Northside Drive. So this is where, if you're staying on the right lane and you turn right, you'll be traveling southbound onto Northside Drive towards the now Mercedes-Benz Stadium. May have been prior to 3:28. I'm not 100% sure at the time.
I'm just gonna to let it play for another minute or so.
There's Mr. Fluet.
So let's pause this here. We are at approximately 3:29. I came into frame about 3:29 and 10 seconds. Is that about right?
That's correct.
Okay. So looking at Mr. Fluet, what sticks out to you about this video?
He's on a cell phone and he's carrying a backpack, and he appears to have the black headwear that we saw on scene. He appears to be wearing that.
And so the direction that he is heading, I know you said it before, but he is heading south on Northside Drive as he makes this turn.
He's getting ready to.
He's
Yes.
getting ready to. Okay. So as you're watching this, what else are you looking out for in this video?
To see if anybody's following him. See if he gets any arguments with anybody up here.
Okay. Do you eventually see a silver SUV in
Yes.
this video? Okay. Do you remember the approximate time that you first see it?
I do not.
Would seeing a copy of your report help refresh your
That'd be great.
recollection?
Thank you. Got it.
Do you remember what time you first see a silver SUV?
Approximately 3:31.
So we're gonna, since we're at 3:30 and 27, we're just gonna kind of let it play. So during this period of time, Mr. Fluid is walking on Northside Drive.
That's correct.
Okay, so this would sort of match up a little bit with the Georgia Tech video.
Yes.
Okay. And when we first see the SUV, do you remember what kind of the way it was driving or what it was doing?
I believe it was turning around.
Okay, so it's making, when we say turning around, like making a U-turn from the direction it was coming?
I believe so, yes.
Okay. So we're looking at 3:31:31. Was that what you just described, that SUV turning?
Yes.
Okay. And does that SUV match the the SUV that you saw in the Georgia Tech video?
Yes, it does.
Okay. Did you then see that same SUV again on this video?
Yes, you do.
Okay, do you remember when that was?
Approximately 3:37.
3:37. So we're now playing at 3:37 a.m. in one second.
This is the vehicle coming up now.
And so what direction does the vehicle head?
It travels northbound on Northside Drive towards Marietta.
And then do you see that vehicle again?
Yes, it'll actually come southbound on Northside Drive and make the right going westbound on Donnelly Hollowell or Bankhead.
And do you remember what time that was?
I want to say it's maybe 3:40 something.
With seeing a copy of your report now, refresh your recollection?
Yeah. Oh, that's close. 3:42.
So let's go to about 3:42, published from 3:42. We're playing from 3:42 a.m. in 4 seconds.
There's the Chevy Tracker.
We're pausing at 3:42 and 50 seconds.
Yes,
So you see the vehicle again.
that's correct.
Okay. Was that type of driving behavior, did you find that to be normal or abnormal?
A little abnormal.
Okay. Having seen that, what's your next step?
See if there's license plate readers in the area.
Okay.
So the VIC unit in 2019, the VIC unit was the one that handled all of that. And so we contacted the VIC unit, and that's where we got the license plate to that particular tag.
Okay. Do you remember who you contacted at the VIC unit?
Yeah, Officer Schiffbauer.
Okay. Was he able to give you a license plate for this vehicle?
Yes, he was.
Okay. Do you remember what that license plate was?
Charlie Ida Robert 8996.
Okay. Now, this is just a general question. You mentioned back in 2019, you had to go to the VIC Center to get that, like the LPR information.
Mhm.
How does that work now?
We do it ourselves at our desk. We have access to all of it.
So with that license plate, information, what do you do with that?
I immediately run the license plate to see who the vehicle comes back registered to or an address that the vehicle comes back registered to.
Okay. Did you get either of those in this case?
Yes, I did.
Okay. So what registered owner did you get and what was the address?
The address was 874 Center Hill, which is in Atlanta, which is not actually too far from the crime scene.
How far would you say it is?
Wouldn't even estimate less than a mile,
Less than a mile? Okay.
maybe a little over a mile. I mean, right there at the mile marker,
Okay,
I would think.
so it wouldn't take you very long to drive there.
No, it would not.
Did you go out to that address?
I did.
Okay.
I went out that same day, knocked on the door. No one was home. So I left.
What's your next step now that you haven't located the vehicle? What do you do?
I placed that vehicle on what we call a hot list. So the LPR system in all of the patrol vehicles, if you place a vehicle on the hot list saying it's wanted for questioning in a specific crime, if it hits an LPR, close by, it'll immediately notify the closest officer. Hey, this vehicle is in this area. It's wanted in questioning for specific incidents. Please locate and identify the occupants.
And do you remember who the vehicle was registered to?
I believe Alicia LaFleur.
Okay. So you put out this this notification. I'm going to refer to it that way. And was the vehicle located?
Yes, it was. I was contacted on that same day on the 14th at 18:30 hours, stating that the vehicle had been stopped by our Apex unit and that there were 3 occupants in the vehicle.
Okay. Who were the occupants?
Alicia LaFleur, Ramel Williams, and his sister, Miss Williams.
Where did you speak with them?
I had them brought down to public safety headquarters, placed in witness rooms, and I spoke with them in the witness room.
Okay. And you mentioned a witness room. Is that different from like an interview room?
Yes, an interview room is a room that locks from the outside and has a shackle to the ground to where your freedom is taken. You can't leave. A witness room, you can come and go as you please.
Do you remember who you spoke with first?
I believe I spoke with Miss Williams first.
Okay. Did you find that she had any relevant information to your investigation?
She was pretty confused as to why she was there answering questions. You could tell she had no idea what was going on.
Okay. Who did you speak with next?
I believe the next person I spoke with was Miss LaFleur.
Okay. And did she indicate where she lived?
Yes, she lived at 874 Center Hill.
Okay. Do you remember who she indicated she lived with?
She lived with Mr. Williams, and there was another male that she only knew as DeAnthony. She was unable to give any further information on Mr. DeAnthony.
Okay. And what was the nature of everybody's relationship?
Mr. Ramel Williams and Miss LaFleur were in a relationship, and she knew DeAnthony through Mr. Williams.
Did she indicate how long she had known that Mr. DeAnthony?
Not very long, a couple of days, I believe.
Did you ask her who had possession of her vehicle at the time, the timestamps that we mentioned earlier on these video clips?
Yes, she stated no one, that her vehicle was at her house. Although she did think it was odd that when she went to bed, the keys to the vehicle were on the dresser, and when she woke up, the keys were in the kitchen.
And when you say they were on the dresser, was she indicating the dresser in her room?
That's correct.
Okay. And the kitchen would have been a common area?
Yes.
Did she indicate that she had the vehicle at that time?
No, she stated she was asleep all night.
Did you ask her who would have had access to her vehicle?
She stated only 3 people had access to her vehicle: her, Mr. Ramel Williams, and his sister, Miss Williams, who did not live at the location.
Okay. Do you remember when she said she woke up?
Around 4 a.m. And I think previously she stated she woke up briefly like 2 a.m. or something.
Okay. Did she indicate who or what was going on at 4 a.m. when she woke up?
No, Mr. Williams was still asleep, according to her. And that was it.
Okay. Did she indicate whether anything was out of the ordinary with the vehicle in the morning when she woke up?
No.
Okay. you mentioned that she said that her keys were in a different place when she went to bed than when she woke up.
That's correct.
Okay. Did you obtain Miss LaFleur's cell phone number?
I did.
Okay. What was the purpose of doing that?
To see basically who she was in communication with around the time of the homicide, if she was in communication with, if she was actually at home during the time of the homicide, which would eliminate her as a suspect, and we would be able to exonerate her from this crime. And if she was actually at the scene at the time of the crime, which means that she had been lying to us.
Do you remember what phone number you got for Miss LaFleur?
I believe it was 404-671-0733.
So 404, you say it's
671-0733.
0733. Okay. Who did you speak with next?
Mr. Williams, Mr. Ramel Williams.
And did you ask him where the vehicle was the morning of the homicide?
Yes, he stated it should have been at the house.
Did you ask him who would have had access to the vehicle?
He said only 3 people have access to the vehicle: him, his girlfriend, Miss LaFleur, and his sister, Miss Williams.
Okay. Did Miss Williams, though, live with them at that location?
No, she did not.
Okay. And did they indicate that, and did anybody indicate that Miss Williams was at the house either that night or that morning?
No, they did not. She came later on to pick up Miss LaFleur to take her to work. She uses Miss LaFleur's vehicle when Miss LaFleur's at work.
Did Mr. Williams indicate that he was working at all at the time?
He stated he was working at Saddle Creek Warehouse off of Fulton Industrial Boulevard.
Okay. Did he say he went to work on that date?
I don't remember if he said he went to work on that date or not. But I know that his shift normally started around 4 in the morning.
Okay. Did Mr. Williams ask you anything that you found out?
Yes, he asked me if the vehicle had been hot wired, or if it had been taken by someone unknown. Told him it was extremely odd that somebody would come into your house, take your keys, steal your car, bring it back, put the keys back in the house, all in time for your girlfriend to go to work.
Did you get a cell phone number from Mr. Williams?
I did.
Okay, what was that number?
404-749-6092.
Your Honor, at this time, the state would tender State's Exhibits 94 and 95, which are the certified records pursuant to OCGA 24-803 for 404-761-0733 and 404-749-6092.
Mr. Francis, any objection to states 94 and 95?
No objection.
Ms. Feely?
Objection.
Both are admitted.
Is getting individual cell phone numbers common practice?
Yes, it is.
Okay. After you spoke with each of these individuals, did they leave police headquarters?
Yes.
Okay. Did you promise them anything, that anything was going to happen by speaking with you?
No,
Did you threaten them in any way?
no, sir.
Okay. What did you tell them about the case?
I told them that the victim was shot probably, it was all on video surveillance. I told them it was all on video surveillance, that it was that vehicle, and we could prove that it was Miss LaFleur's vehicle that was on scene based off of video surveillance and license plate readers. And we needed to know who was in the vehicle at the time that Mr. Fluette was shot and killed.
Did you tell them like where to go or where not to go or anything like that?
No.
Okay. Um, So you said that there was a traffic stop on the Chevy Tracker, is that right?
That's correct.
Okay. And at that point, who takes possession of the vehicle?
I do.
Okay. Where do you take the vehicle?
The vehicle is then taken to our annex over on Donnelly Hollowell Parkway, and where it's then placed in a cage and it's secured and locked.
And in order to look through a vehicle, is there a step you have to take?
Yes, so I needed to obtain a search warrant in order to search the vehicle, process the vehicle, do anything with the vehicle. So I did that prior to having crime scene meet me out to process the vehicle.
So I'm showing you states exhibits 49 through 87.
Mhm. Thank you.
So 48 through 51 are already in. You can share with her anything you want, but my records are that through Ms. LaFleur, you admitted 48 through 51.
That's correct, Judge.
Okay.
Do you recognize those?
I do.
Okay. And how do you recognize those?
This is the photographs that Crime Scene Tech Ware and I took while we were at the cage, the annex of the Miss LaFleur Chevy Tracker,
Okay. Do you remember when you processed the vehicle?
January 16th.
Okay. So was that the same day as the traffic stop?
No, the traffic stop was at 18:30 hours on the 14th, which was the same day as the homicide. After the interviews, I went home to get a few hours sleep. Came back, and that's when I got the video surveillance. And then the following day, the 16th, is when I obtained the search warrant and went and processed the vehicle.
Okay. Your next time the state tenders states exhibits 52 through 87.
Mr. Francis, any objection 52 through 87?
No, Your Honor.
Ms. Feely?
No.
Okay, admitted.
States exhibit 48. Is that the Chevy Tracker?
Yes, it is.
Okay. And in looking through the Chevy Tracker, do you document the interior and exterior of the vehicle with these photographs?
Yes, I do.
Okay. Did you do any sort of, or you or the crime scene tech do any sort of processing of the vehicle?
Yes, so we processed the inside of the vehicle with DNA, where we take swabs and we swab the steering wheel, the gear shifter, any place that's a regular part that a driver would touch. And then we also, I requested that crime scene tech fingerprint the outside of the vehicle and parts of the inside of the vehicle to see if we could get any possible prints from the vehicle.
Gotcha. And are fingerprints and fingerprint analysis something that you use?
Yes.
Okay. What is the purpose of the latent prints examination for you?
To identify anybody that was possibly in or around the vehicle.
Were you there when the tape lifts were taken?
Yes, I was.
Okay. And were you aware whether or not the latent prints came back or identified anybody?
I am.
Okay. Who did those latent prints identify?
Mr. Tolbert.
Did you When you were looking through the vehicle, did you look for any evidence of it being hotwired?
Yes,
Did you look for any evidence of it being, stolen or tampered with?
yes,
Okay. Did you see any evidence of that?
no. Vehicle was in good working condition and it had not been tampered with.
Did you locate any other pieces of evidence significant to your investigation in that vehicle?
Yes, both of these cell phones were actually located in the center console. We took them out to photograph them.
What
prior-
exhibit is this?
This is.
'56 and '57.
56 and 57. Okay, thank you.
So we're looking at states exhibits 56 and 57.
This one's '57.
Okay, so looking at 57, you indicated that there are phones in the vehicle.
That's correct.
Okay. When you see phones in the vehicle, what do you do?
I first see if they're in working order, if they turn on, if they have a passcode, and then immediately try to get a phone number for them so I can get a search warrant for the phones.
In this case, were you able to identify cell phone numbers with those two phones?
Yes, by calling 911.
Okay. So explain that process to me.
Well, 911 is not very happy when we do this, but sometimes when the phone is locked, you can still call 911 from the phone. So we call 911, we tell them, hey, I'm Detective Benton, Atlanta Police Homicide. Can you tell me what number I'm calling from? They then advise us what number we're calling from. And that's how we're able to then get a search warrant for the historical call detail records of that phone, and also a separate search warrant to be able to dump the contents of that phone.
In this case, did you get the phone numbers for each of those phones?
I did.
Okay, what were those phone numbers?
The first one I do not remember. The second one was a 678-548-6988 number. And the second one, I don't recall that phone number.
With respect to the 678-548-6988 number, ultimately, were you able to link that phone number with anybody?
Yes, I was.
Who were you able to link that phone number with?
Anthony Tolbert.
And Your Honor, at this time, the state tenders into evidence States Exhibit 96, the certified business records for cell phone number 678-548-6988.
I'll ask in just a second. The exhibit list says 6998. I just need to know what the number is. I can either correct the exhibit list or we need to clarify the testimony.
It's 6988?
Yes.
Yes.
Okay. Ms. Feely, any objection to the admission of States 96? Mr. Francis?
No, Your Honor.
Admitted.
So once you have that number, what do you do with it?
I get a search warrant for the historical call detail records and per call measurement data for that phone number.
And is that's the same thing that you did with Ms. LaFleur's phone number and Mr. Williams's phone number?
Yes, it is.
Okay. Did you eventually receive cell phone records back from Mr. Ramel Williams?
I did.
Okay. And based on those records, what did you do?
Based on those records, I obtained arrest warrants for Ramel Williams for the murder of Frank Fouet III.
Now, when that happens, once you've done those warrants, is there something that you do or submit to anybody?
Yes, so you have to immediately flag the warrants on the system, which since it's a murder warrant, it's a nationwide pickup. And I put together a fugitive package, and Detective O'Hare took possession of that package and took the fugitive case.
With the information that you had, did you also conduct a photo lineup?
I did,
Okay, who'd you conduct that photo lineup with?
Mr. Wiley.
Okay. And how is a photo lineup conducted?
So a photo lineup, we do a 6 photographs, 6 single photographs. And we have somebody who's not well acquainted with the case or knows who the suspects are. They actually present the photo lineup so that's not biased in any way. And so the person will go in and they'll read a photo lineup admonition. And then once they read that, they'll then shuffle the photographs that are all, they should be in manila folders. They will hand everything over to the person. They will be hands off, and they will ask the person to open each folder, look at the photograph and see if they recognize anybody.
And in this case, did Mr. Wiley recognize anybody?
I don't believe so.
Or did he recognize the person that you put in there that you would think he would recognize?
No, he did not.
Well, did you put a photo of Mr. Williams in a lineup for him?
I did.
Okay. Did he pick Mr. Williams?
He did not.
Okay. Is that ultimately surprising to you?
No, he had stated that he never really saw the driver of the vehicle, that he sort of saw a glimpse of the passenger. But just in case, we went ahead and did the lineup anyway.
Okay. During this period of time, did you call Alicia LaFleur or speak with her?
I did. I contacted Ms. LaFleur to let her know that her vehicle was ready for pickup at the tow lot.
Okay.
And she advised that she was in Chicago with Miss Williams and that Mr. Williams was still here in Atlanta.
Okay. Do you remember what day that was?
I want to say it was the 20th or 21st of January, 2019.
Did you also contact or speak with Mr. Williams?
Later on that afternoon, Mr. Williams contacted me from Ms. LaFleur's cell phone number.
So from Ms. LaFleur's cell phone number?
That's correct.
Where did he say he was?
He stated he was in Chicago with her and his sister.
Okay. Did you ask them about DeAnthony at all?
I did. I asked Mr. Williams if he had any further information on DeAnthony, that if he could give me any further information. And he stated that he had kicked DeAnthony out of the house, or Miss Williams had kicked DeAnthony out of the house, and that he could give me any other information.
Did you tell her that you had any new information on the case?
No,
Did you tell her about arrest warrants or anything like that?
no.
Okay. Do you remember contacting Mr. Williams' employer?
I do.
Okay. Do you remember what day you contacted them?
I want to say it was the 21st of January.
Do you remember what you learned from them?
I learned that Mr. Williams was actually worked for a temp agency called the Reserve Network, and that Mr. Williams actually did not show up for his scheduled work time on the 14th at 4 a.m, the day of the homicide. He was a no-show and no call.
Were you made aware of the circumstances of the arrest of Ramel Williams?
I was.
Okay. Do you know where he was arrested?
He was arrested in Chicago.
Okay. Do you know who was present at the time he was arrested?
DeAnthony Tolbert.
Did you have any indication that DeAnthony Tolbert had any connection to Chicago?
No, I did not.
Do you happen to know where either Ramel Williams or DeAnthony Tolbert are from originally?
At the time, no.
Okay. Do you now?
Yes, I believe Mr. Tolbert's from here in Georgia, and Mr. Williams is from the Illinois area.
Were you aware of any reason for Mr. DeAnthony Tolbert to be in Chicago?
He stated he was there for a family friend's funeral.
And did you ultimately get records back from the phone number that you associated with Mr. Tolbert?
I did, yes.
And once you got that information back, what did you do?
I placed the arrest warrants out for Mr. Tolbert for the murder of Frank Fluette III.
Do you see Mr. Ramel Williams in court today?
Yes, but he's blocked by the screen.
If I move the screen, will you be able to? get a better
Let's
view?
not move the screen. Let's move the witness. Yeah, no,
Yeah.
I'd rather move you because that screen, we touch it and the lights go off and the AC stops working.
Yes, I see him.
Okay, can you describe him in an article of clothing that he's wearing?
Yes, he's actually in a nice dark suit, a white shirt and a yellow tie.
Your Honor, let the record reflect that this witness has identified Ramel Williams.
She has?
And is this the same Mr. Williams that we've discussed in this case?
Yes, sir.
Is this the same Mr. Williams who had access to that Chevy Tracker?
Yes, it is.
Is that the same Mr. Williams who made statements to you?
Yes, it is.
Is it the same Mr. Williams that you got the phone number from?
Yes, it is.
And it's the same Mr. Williams that you got the phone records for?
Yes, it is.
And what about D'Anthony Tolbert?
He's actually at the edge of the table wearing a blue dress shirt and a blue tie with a black mask on.
In this case, in Your Honor, let the record reflect that this witness has identified D'Anthony Tolbert.
She has?
And is this the same D'Anthony Tolbert that you were made aware of in this case?
That's correct.
Is this the same D'Anthony Tolbert that you learned the latent prints about?
Yes.
Same D'Anthony Tolbert that you got cell phone information for?
Yes, sir.
Were you able to speak with Mr. D'Anthony Tolbert?
So I'm going to have us do our morning break right now. I should have caught just before you started, you had a longer pause, but we've gone about an hour and a half. We're going to break for lunch, not till about 1. So it's a slightly later lunch. So I had us go a little bit later today. We also started a little bit late because of our situation with the juror we lost. So you all are going to get about 10 minutes. We'll try on that clock to be back around 11:15. Remember, don't talk about the case, no outside research, just enjoy that space and each other's company and the snacks, and feel free to use that long hallway as well. And we'll see you in about 10 minutes. Thank you.
All right, adjourn.
All right, you all can be seated. Mr. Trepanier, how much more time do you think you have with this witness, since you told us you were probably going to rest by around lunchtime? And I'm guessing you've got a few more witnesses.
This will be the last section of my direct of Detective Benton.
Okay.
So it's the interview portion with Mr. Tolbert, and then maybe a brief wrap up.
Okay. You've got a medical examiner and a Leon Packer-esque witness, and I guess a few GBI people.
One individual from GBI.
Okay. And the medical examiner shouldn't be all that long because cause of death really is not an issue in this case, as I understand it.
That's correct, Judge. I don't anticipate it being overly long. I also don't anticipate GBI being extensive either.
Okay. Anything else you want to talk about before we break?
I mean, it's the same issue that we're gonna address with respect to Detective Benton's testimony regarding Mr. Tolbert's statements.
Okay, I'm gonna have you step outside if that's okay. They'll get you back in here when the break is over. Thank you.
So
I'm gonna keep standing because I've been sitting for a while. You can sit, you've been standing for a while.
Standing for a while.
Yeah.
This is the point where I anticipate getting into the testimony.
Oh, I understand. Right.
That's and just wanted to let the court and counsel know. So
Well, I'm gonna ask Ms. Feely again about a limiting instruction. There's another reason to take the break now. But you still intend to use revised Plan 6 you brought up this morning, which is you're gonna have Detective Benton simply say, my words, not hers. Mr. Tolbert told me he was there. Mr. Tolbert told me he was present for the shooting and not say he was there with someone else.
That's the plan, Judge.
Okay, for that, I don't know that we need to give a limiting instruction, but I'm happy to start with that so that the jury knows that testimony about what Mr. Tolbert may have said should be used only against him at this juncture. I may have to unwind that instruction if Mr. Tolbert chooses to testify, but we're not there at that point. Have you changed your view about when I should give the limiting? You had requested do it just before Mr. Francis starts his cross-exam.
So we would actually prefer to the court went ahead and gave it before it was mentioned at all.
Okay, so when the jurors come back in, got it. Do you have anything else you want to discuss before the break?
No.
All right, Mr. Francis, anything new, different, or exciting from you?
No, Your Honor, not at this time.
Okay, great. Enjoy your 10 minutes. We'll see you in a little bit. Okay, let's get back on the record in State versus Williams and Tolbert. We are still in the state's case. Can we get Detective Benton heading back this way, please? Mr. Trepanier, anything before we bring the jury in?
I don't believe so, Your Honor, no.
Ms. Feely, I plan on telling the jury that any evidence they may receive about statements Mr. Tolbert made concerning his possible involvement in the alleged crime should be considered only as to Mr. Tolbert. Something to that effect work for you?
Yes, Your
Okay, anything else for Mr. Williams?
Honor. Not at this time.
Mr. Francis, anything else?
No, Your Honor.
Okay, great. Why don't we get the jurors coming in as well? They'll collide. You can come on up. You're already sworn in. Just took a break. You good? You good? We can talk at the break, okay?
All right, for the jury. Mr. President, accounted for.
Thank you, Deputy Gordon. Everyone else can be seated, please. Welcome back. We remain in the midst of the direct examination, the state's examination of Detective Benton. I need to give you all what's called a limiting instruction. You may hear through questions Mr. Trepanier asks, and if either defense counsel decides to ask questions of Detective Benton, you may hear testimony concerning statements Mr. Tolbert made that may in some way implicate Mr. Tolbert or connect Mr. Tolbert to the allegations in this case. Those statements allegedly made by Mr. Tolbert may be considered only against Mr. Tolbert, his words against him and not against Mr. Williams. Okay? Mr. Trepanier.
All right, I'm just going to take one step back before we talk about Mr. Tolbert. When you spoke with Mr. Williams on the phone, did he tell you why he was in Chicago?
I believe for a funeral.
Were you able to speak with D'Anthony Tolbert?
I was, yes.
Okay. Prior to speaking with him, what did you do?
Prior to, made a video, turned the video recording on inside the interview room.
And do you issue Miranda warnings when you speak with somebody?
If someone's in custody, I always issue Miranda.
Okay. And at this point, was Mr. Tolbert in custody?
Yes, he was.
Okay. And what are Miranda warnings? Can you tell the
Miranda
That's right.
warnings are a defendant's right to remain silent and to not self-incriminate themselves, and to have a lawyer present if they request one.
And if they can't afford one, would you provide an attorney for them or allow them to speak with a lawyer first?
I would not provide them with an attorney. That the court would provide them with an attorney if needed. And I'd be more than happy if they have an attorney that they want to make a phone call. I'll be more than happy to give them a phone and they can call that attorney.
And if Mr. Tolbert chose not to speak with you, you wouldn't have spoken with him?
That's correct.
Okay. Did you make Mr. Tolbert aware of his rights?
I did.
Did he waive those rights and agree to speak with you?
Yes, he did.
All right. Did he indicate where he was living in Atlanta?
He stated he was basically homeless, and that he had been living at 874 Center Hill for a short time.
Did he indicate whether or not he drove Alicia LaFleur's vehicle?
Stated he never did.
Um, When you asked him, he originally stated that he was not at the scene of the shooting of Frank Fluid. Is that correct?
That's correct.
And that when you provided more information, did he then change his story to say that he was present when Mr. Fluid was shot?
Yes,
And did he say that he did not shoot Mr. Fluid?
that's correct.
Showing opposing counsel what I marked as states.
114?
114.
Okay. You have a habit of turning away from the microphone when you get to the exhibit number, and poor Ms. Rivers can't hear that part. So 114.
114. Yes, Your Honor.
Got it.
You recognize states exhibit 114.
I do.
And how do you recognize that?
That's Mr. Frank Fluid III.
And was that Mr. Frank Fluid III as he appeared in life?
Yes,
So it's not been admitted yet?
Oh.
May not want to put it up till we see.
And Your Honor, at this time, the state tender states exhibit 114.
Okay. Ms. Feely, hopefully no huge objections to the admission of 114. Okay, Mr. Francis, it's admitted, and yes, you may publish.
And this was Mr. Frank Fluid III.
yes, sir.
In some, what combination of reasons were there that you ultimately took out arrest warrants for Mr. Tolbert Williams?
So we knew that he had access to the vehicle based off of his statements. We knew that he lives at the same location with the vehicle owner. We knew that the vehicle that he had access to was used in the crime scene. It was at the crime scene at the time of the homicide. And then after getting his cell phone records stated that he was not at 874 Center Hill, that he was actually on the crime scene at the time of the incident.
And what were the reasons that you took out arrest warrants for DeAnthony Tolbert?
Fingerprint identified him on the outside of the Chevy Tracker, even though he stated that he had never been in the Tracker. And once we got his cell phone records back as well, his cell phone records basically were traveling with Mr. Williams on the morning of the January 14th, 2019, and that he also was on scene at the time of the incident. And based off of the witness of Mr. Wiley stating there was only 2 individuals inside the Tracker, those were our 2.
No further questions, subject to redirect, Your Honor.
Ms. Feely, questions for Detective Benton?
You're just saying that when you were taking out arrest warrants for Mr. Williams, that his phone records put him at the scene? Is that what your testimony?
Yes, ma'am.
So what you mean though, is it puts his phone at the scene, right?
But correct.
So it is phone records that put his phone at the scene.
And the vehicle that he was, yes, correct.
And I want to make sure I have your stats correct. I think you've been in law enforcement 22 years?
Almost.
Almost. And with homicide for 14 years.
A little over, yes.
So fair to say you've had pretty extensive training, right?
Yes, ma'am.
Including in investigations
Yes, ma'am.
and how to collect evidence.
I don't collect the evidence. The crime scene techs collect the evidence.
So-
But I've had training in sort of kind of collecting evidence, yes.
And it's your call what evidence you direct them to collect, right?
Most of the time, yes.
And I talked a little bit about you have a training and experience in preserving evidence,
Yes, basic training.
making sure it's not contaminated in any way.
Yes, ma'am.
And you did that here.
Yes, ma'am.
You also have experience conducting or asking for search warrants,
Yes, ma'am.
and you did that in this case.
Yes, ma'am.
And you have experience executing search warrants,
Yes, ma'am.
and you did that in this case.
Yes, ma'am.
And even with all of that investigation you did, you were unable to locate any physical evidence tying Romel Williams to the crime scene, right?
Yes, this is a yes.
So no DNA,
No,
no fingerprints,
no,
no blood,
no.
no articles of clothing,
On the actual crime scene, no.
no video footage that actually shows Romel Williams.
No.
And you already talked about there was no witness who was able to identify Mr.
Correct.
Williams. And no other witness besides Mr. Wiley said they saw two people in the car, right?
That's correct.
Now, you mentioned the 6-person lineup. You put that together, right?
Yes, ma'am.
And you included a photo of Romel Williams.
Yes, ma'am.
And best practices, you got a different law enforcement officer to administer the lineup to Mr. Wiley.
Yes, ma'am.
And you testified that he was unable to pick out Romel Williams, right?
Correct.
Not only did he not pick out Romel Williams, he actually selected one of the filler photos, right?
Correct.
Do we have any information on who that person was?
Somebody who was in custody at the time of the homicide.
And you mentioned that Alicia said, for whatever reason, that Mr. Williams was not in Chicago when she was in Chicago.
That's correct.
But Mr. Williams called you back and said he was in fact in Chicago, right?
That's correct.
You said on direct that Mr. Williams was a no-show, no-call on January 14th, 2019.
The Saddle Creek warehouse, yes.
And do you remember who you spoke to?
No, I do not.
Would it have been Al Vasquez?
I wouldn't even recall.
Because this was 4.5 years ago.
Correct.
The two cell phones that were found in the car that you got the search warrant for and searched, neither one of them belonged to Romel Williams, right?
That's correct.
And do you remember testifying at the preliminary hearing related to this case?
I remember there was most likely a preliminary hearing. I'm not sure if I remember everything about that. I think that was about 4 years ago.
And it was your testimony on direct that one of those two cell phones was Mr. Tolbert's cell phone.
Yes.
Right. And you testified that you used the phones to call 911 is how you got the numbers. Is that right?
Yes, ma'am.
And this was on January 16th of 2019.
I believe so. Yes, ma'am. The day we processed the Chevy Tracker.
And one of the two numbers was 678-507-8948.
Yes.
And one of the numbers was 678-548-6988.
Yes, ma'am.
And at the time, your research for those numbers showed that 678-507-8948 was registered to Brandon Smith, right?
Based off of a generic, like LexisNexis search.
And the number 678-548-6988 was registered to Chatasia Williams.
Mhm.
And both of those people you contacted, or I'm sorry, neither one of those people had reported their phones stolen.
Correct.
And these two phones were located in the suspect vehicle in the center console.
Yes.
Now, when you interviewed Miss LaFleur, you at that point knew that her vehicle was at the scene of this homicide, right?
Correct.
And so fair to say you hadn't ruled her out as a suspect.
No,
And you in fact asked her, I know you were in the car at 4 something this morning, right?
Can you say yes or no?
right, yes,
Answering, thank you.
And you asked her, do I need to charge you with murder?
yes,
And you told her, I don't think they meant to kill him because he was shot in the leg.
correct,
And he wasn't shot dead center in the head or anything like that.
correct,
And you told her, you know the answers before you ask the questions.
correct.
And I'm not saying you gave them permission to have the car, right? You told her that.
If you're saying that, yes,
And if you don't tell me, you would be an accessory to murder,
possibility, yes,
which means you would be charged for just as much as the person who actually did the murdering.
that's correct.
And you knew that she was pregnant, right?
I believe I did, yes.
And you told her you'll have the baby in jail.
Yeah.
And you'll never see the baby again.
That's typically how it goes.
But even after all that, she told you she doesn't know she was asleep, right?
That's correct.
You know, you testified on direct that Mr. Williams' home that he shared with Alicia was a little over a mile from the crime scene. Is that right?
I'm approximating. I couldn't give you an exact distance.
So if Google Maps said 3.7 miles, that wouldn't surprise you.
No,
Thank you. That's all I have at this time, Your Honor.
Mr. Francis, do you have questions for Detective Benton?
Hey, good morning.
Hi.
Detective Vinton, how are you?
I'm good. How are you?
All right, we've done this for a lot of years.
Oh, yes.
I just need to clear some things up.
Yes, sir.
The 6'9", because the jury won't have access to your testimony after you're gone.
Okay.
Just have to remember.
Okay,
The 6988 number was a number that was linked to Mr. Tolbert.
correct.
Not that he owned that cell phone that had that number or anything like that.
I wouldn't know if he owned it. I can just say we were able to link him through it to that number.
As a matter of fact, you get the number because in his report, he indicates that he told someone they could contact him by that number.
Correct,
Right. But the number is actually owned by someone else.
correct,
Okay, that's just to clear that up. And the print of Mr. Tolbert is on the passenger side of the door.
correct.
Okay. And when he talked to you, he said he was a passenger in the vehicle that night.
That is correct.
Right. And he told you that he wasn't in a fight with anyone.
No,
He didn't shoot anyone.
no,
He didn't rob anyone.
no,
Okay. And that he didn't have access to this vehicle.
no,
He never drove this vehicle.
correct.
Okay. And that he did go to Chicago.
That is correct.
Okay. And that he was afraid of someone in Chicago.
That
Did
is
he tell you
correct.
that? Okay. I don't think I have any further questions.
Mr. Trepanier, do you have any redirect?
Just briefly, Judge, 1 second. So just briefly, when you administer a lineup or put together a lineup, are the people in that lineup meant to look similar?
Yes.
Okay. What's the purpose of making them look similar?
You don't want the lineup to be biased. So you don't want to put someone who is 500 pounds and 5 people who are 80 pounds in a lineup because, it'll be biased towards that person. So you're supposed to make sure that the lineup, the filler photos is what we call them, are of similar complexion, race, weight, hair, earrings, facial hair, everything.
So the filler photos that you used were meant to look similar to Mr. Ramel Williams.
Correct.
And Was it surprising to you in any way that Mr. Wiley did not ID Mr. Williams?
What's the relevance of whether this detective was surprised?
I'll rephrase.
Okay.
What was, how well lit was the crime scene?
It was very dark.
Um, as part of being a homicide detective, do you learn interviewing techniques?
I do.
Did you apply those interviewing techniques in this case?
Yes, I did.
Okay, and that included with Miss Alicia LaFleur?
Yes, sir.
When you spoke with Mr. Tolbert, did he say anything about an earring being ripped off?
I don't believe so. I don't recall about that.
And did he say anything about a gun being jammed?
No.
No further questions. Thank you, Judge.
Ms. Feely, anything else? Mr. Francis, are there questions from the jurors for Detective Benton? Okay, Detective Benton, thank you for your time. And ladies and gentlemen, I need to remind you again that any testimony that you heard about statements that Mr. Tolbert may have made to Detective Benton that in any way connect Mr. Tolbert to the charges that are before you are at this point to be considered only against Mr. Tolbert and not against the other defendant. I would follow direction from them. I'm excusing you for today. I wouldn't leave the city of Atlanta or at least the metro area. Great. Next witness.
Yeah, the state calls Detective William Packer.
You swear affirm the testimony you will give will be the truth, the whole truth, and nothing but the truth, so help you God.
I did.
So Lord, here, have a seat. State your spelling name for the record.
My name is Kevin Leon Packer, Leonpacher.
Good afternoon, Detective William Packer.
Good afternoon.
Can you tell the court where you're currently employed?
I'm employed by the City of Atlanta Police Department, and I'm currently assigned to the homicide unit.
Okay. Can you describe your duties?
I'm a detective in our homicide unit. I'm a part of a special, I've been in homicide for over 13 years now, with the police department for over 21 years now. And my responsibilities in homicide are to conduct death investigations. I'm a part of a specialized group now after having been there for a while, called the Complex Case Squad. And traditionally in the Complex Case Squad, we work homicides that may be complex in nature. And by complex, I mean it may be like a series of armed robberies and eventually it culminates to a homicide. We'll go back and adopt all of those prior incidents as well, even though they're not homicides, but may be related. And we'll work the complex series of crimes. We also work complex cases, death investigations if they're suspicious in nature, sometimes suicides if they involve firearms, officer-involved shootings, in cases that may be of media notoriety of particular importance to the city or to the police department. We are extremely busy right now compared to years past. So instead of work catching specialized cases, now everyone in the Complex Case Squad is also in our regular case rotation. So my responsibilities currently are to be in an on-call status and respond to homicides as they come up when my number's up. We have magnets on a board with our names on it. And when we're at the top of the list, we'll get called in for the next homicide, no matter what time of day it is, if it's during our regular shift or not. My most recent case being about a week ago at about 3 o'clock in the morning. So it's whatever the departments requires, those are my responsibilities.
Okay, and are you post-certified?
Yes.
Can you tell the jury just an estimate of how many homicide cases you've had an opportunity to investigate?
In the past 13 years, hundreds of homicides. I honestly don't know the number. For the first few years in homicide, we averaged 80 to 90 criminal homicides a year. And that doesn't count the homicides that may be considered non-criminal. For instance, if someone were to be engaged in a felony when they were killed, we may still seek charges against co-conspirators that were involved in that crime, even though the killing of the offender was not criminal in nature. So 80 to 90 criminal homicides, but over 100 every year as long as I've been there. And now we're averaging around 160 a year. And hundreds of homicides I've led the investigations into, and many more that I've assisted in investigating over the years.
Okay, you've testified as to cases that you've served in a lead capacity as an
Yes.
investigator. You've also testified as to cases that you've assisted with other lead detectives. What type of assistance would you provide in your duties with other detectives, other lead detectives?
I participate in case consultation. Sometimes when a lead investigator gets stuck on an investigation and they're looking for looking to generate new leads, following different avenues of investigation. Oftentimes, I or a team with the complex case squad will sit down and consult on the case, maybe chase digital evidence that they hadn't chased before, recanvassing, looking for video surveillance, looking through alternate sources of records of information that may help identify a person of interest, or again, generate new investigative leads. I also have developed a specialized skill set in working with digital evidence and specifically working with historical cell phone records, with live cell phone records. Sometimes when we track people, track devices, I should say, using surveillance methods, and also working with digital forensics, cell phone forensics, dumping cell phones, working with the forensics that we can obtain from vehicles now, just about anything and everything that might further a case investigation, and in any way we can assist with any other investigator.
Detective William Packer, if you could give us an estimate as to how many investigations you conducted using either historical cell phone data or tower cell phone analysis.
Again, hundreds. In the majority of cases that I've worked since I've been in the homicide unit, we've in some way encountered cell phone records, and it may have an implication just in who called whom when. We might want to know if someone was in communication with someone. It may be looking for needles in a haystack. If we had two homicides that we believe to be related, looking at massive amounts of cell phone data in two different areas to see was one cell phone at both scenes. And also I've assisted across the state and other parts of the country with cell phone records analysis for other cases as well, and not all homicides. So if I had to estimate over the years since I've been working with cell phone records, it probably exceeds over 1,000 cases.
Can you describe your training and education that allows you to perform these functions of APD?
Sure. So again, when I joined the homicide unit in 2010, our case files were mostly paper-based. It was summaries of interviews and just following traditional investigative methodologies. It didn't take long before we started collecting more digital evidence, including cell phone records. When we were obtaining phone records during that time period for the first few years that I was in homicide, we conducted layperson analysis of those records. We read the tip sheets from cell service providers and began to apply what we knew about how cell phones communicated with cell records from a layperson perspective to the criminal investigations that we were conducting. In 2014, I took my first formalized training in cell phone historical cell site analysis. And that was with the Public Agency Training Council. That's the, at least it was, I presume it still is, the largest non-government entity training group within the United States, specifically for law enforcement. And that was cell phone technology and forensic data recovery. That was a 40-hour course. And that focused on formal training on analyzing cell phone records from the various service providers like Sprint, T-Mobile, AT&T. Then Metro PCS was its own company. And now it's been absorbed by 2 other companies since. But it was just formalized training. In 2015, I began training with a specialized group within the Federal Bureau of Investigation called the CAST team. That's a Cellular Analysis Survey Team. That's a group of agents with specialized training in working with cell phone records. Again, historical and live tracking of devices in certain situations. And that was, I believe, a 16-hour course. Then the following year in 2016, CAST had revamped their program, added some new information from cell service providers as it became available. I retrained with CAST in 2016. That was 24 hours. 2018, I trained with Hawk Analytics. That's a private company. They provide tools for plotting out, providing visual representation of plotted cell phone records, so we can see where a phone is in relationship to an area of interest in investigations, or at least was in that area historically in investigations. And that was 24 hours. In 2018, I received some training from another company called GeoTime, and it was a basic cell site analysis. That was 8 hours. In 2019, again, I trained with the CAST team. That was 24 hours. 2022, I trained again with the CAST team. That was 16 hours. In 2023, I took some online training with Hawk Analytics again, but it was for connected vehicles. As most modern vehicles now, about 2018 and newer, have embedded SIM cards. So they're rolling cell phones. And received some specialized training on using those call detail records from vehicles instead of what is a traditional cell phone in criminal investigations. Okay. And then this year, I have been a recently appointed task force officer with the FBI Atlanta field office. I'm still brand new. I haven't been sworn in yet with a respective federal agencies to have arrest powers federally. But getting this TFO position, which will essentially lead to me being at least part-time embedded with the FBI, conducting some state and local investigations, but also participating in some federal investigations. It's broken down a barrier for me to do some more specialized training with the CAST team, and that is to go through a CAST certification curriculum. And this year was the beginning of that advanced training. Back in, I believe it was May is when I took the first CAST advanced class. And that was 1 week of training utilizing, with a focus on utilizing advanced methodologies and working with cell phone records. There's some newer engineering data that we're starting to take into consideration that can yield some better results and accuracy of where a device was in relationship to a cell phone tower, rather than making broad generalizations, but also with a focus on working cases in totality, not just looking at phone records, but looking at other sources of digital evidence in conjunction with phone records. And then again, I trained with the CAST team with the training was a critical incident readiness assessment. And it was in part training, but also a class on assessing our ability to handle a critical incident, for instance, a kidnapping, a homicide, an active shooter situation, or any major incident that would require retrieving records quickly, drawing conclusions efficiently and correctly, to identify a suspect or recover a missing person, a kidnapped person, someone that's been the subject of human trafficking. And we worked through real life cases that were worked historically by the FBI. And both of those advanced classes were pass-fail. I passed, and starting next month, I'll be continuing through the final certification process, which will be 4 weeks of additional training.
Okay. Now, Detective Leonpacker, can you tell the jury why, what is the significance or importance of continuing to get the training in this field?
Well, the way that, first off, the technology changes that cell phone companies use. Most recently, the rollout of 5G technology. That's going to, we've seen a little bit of 5G and records that are being returned now for active cases we're working now. It hadn't rolled out in 2019 yet to the public. But the way that we plot those records out and the conclusions we draw from the records that we analyze are a little bit different. So the technology changes, and also just having a constant refresher of the information we already know. In addition, the gap between what network engineers for these cell service providers know and what the law enforcement compliance divisions know when they produce records. They may produce records, but the law enforcement compliance people may not know why they're created or how they're created. And this goes beyond just who called whom and when, or what cell phone tower they used. There's some engineering data that sometimes gets stored by phone companies, and they will produce that data, but the law enforcement compliance folks, they don't understand it, and they don't know why it's created or how it's created. And that gap has begun to shrink a bit because the CAST team is probably the on the forefront of closing that gap by training annually with those engineers from the cell phone companies to shed light on what these records mean, why they're created, how they're created, and then we begin to get a better understanding of it so that we can form an expert opinion on these records when we retrieve them, we analyze them, and again, apply them to the investigations that we're conducting.
Okay. And Detective Leonpacker, have you had an opportunity to teach or instruct others on this type of technology?
Yes.
And what settings or opportunities have you had to do that?
I have participated in dozens of presentations as a speaker throughout the United States and internationally. I have provided instruction at the Atlanta Police Academy, internally at APD and other settings here at the Fulton County District Attorney's Office, through the State Prosecuting Attorneys Council at their respective conferences where prosecutors go, just like we have to have annual training every year. So do prosecutors to have their continuing legal education requirements. I presented in that setting as well. I've presented at several technology-based forums, some hosted by government agencies, including the Federal Bureau of Investigation and the National Domestic Communications Assistance Center at their Law Enforcement Technical Exchange Forum. The Massachusetts Attorney General's Office hosts a cybercrimes conference annually. The International Association of Chiefs of Police Conference, Techno Security and Digital Forensics conferences, and again, across the country. And I was invited to Stockholm, Sweden, to present to a digital forensics company where I talked about how we're using this evidence in criminal investigations, not only historical cell site analysis, but also the forensics of mobile devices.
Okay. Prior to today's date, have you ever been called to court to testify as an expert in this field?
Yes.
How many times?
38 times I've been qualified as an expert, and I've testified additionally without qualification in certain trials.
Okay. And would that be in Superior Court, state courts throughout the county?
Yes, in both Fulton and DeKalb County.
Okay. Have you ever been qualified as an expert in the field of historical cell phone data and cell phone tower analysis?
Yes.
Okay. And the times that you testified to, was it in that capacity?
Yes.
That you've been qualified as an expert?
Yes.
Okay. Your Honor, this time the state will move to tender Detective Kevin Leonpacker as an expert in historical cell phone data and cell phone tower analysis.
Ms. Feely, do you want to examine the detective in this area? Any objection to having him qualified as an expert in those two fields? Mr. Francis?
No, Your Honor.
No objection? Okay. Detective Leonpacker, for the purposes of this trial, I qualify you as an expert in the fields of historical cell phone data analysis and cell tower data analysis.
Leonpacker, when he was with Mark States Exhibit 97. You recognize this exhibit?
I do.
How do you recognize this exhibit?
It's printed off slides of a PowerPoint that I created to help with to aid in my testimony to the records that I analyzed in this case.
Okay. Your Honor, this time the state will move to tender in to evidence. It's a demonstrative exhibit. We're tendering for that purpose, Exhibit 97.
Any objection, Ms. Feely, to states 97 as a demonstrative?
No.
Mr. Francis?
No, Your Honor.
It's admitted.
Now, Detective Leonpacker, did you use the training and experience that you've been testifying to in this case?
Yes.
Okay. What items did you have an opportunity to review?
I reviewed phone records that were obtained for Mr. Williams, Mr. Tolbert, and Ms. LaFleur. Mr. Williams and Mr. Tolbert were Mr. Tolbert, D'Anthony Tolbert, the phone number that was associated with him as the records were provided to me was 678-548-6988, and those were Sprint records. Mr. Williams was 404-749-6092, and those were Sprint records. And Ms. LaFleur was 404-671-0733, and those were T-Mobile records. So I got 3 different sets of records. And for Ms. LaFleur, those records were call detail records, basically, again, who called whom and when. And for Mr. Tolbert, Mr. Williams, the records included not only call detail records, but some data usage for the device with cell site location information and some timing advance records, which I can explain when the time is right for what timing advance records are.
Okay. All right. Now, as far as the admitted exhibit, States Exhibit 97, you were testifying that this is the presentation that you prepared for your testimony today.
Yes.
Okay. Now, we could go through your Exhibit 97, and if you could turn to the next slide and tell the jury about these items needed to plot or determine a wireless activity of an individual.
So to make a graphic or visual representation of where a cell phone was at the time that there was activity between the cell phone and a cell phone tower, we need records that tell us, they're called detail records is the title of them, but we need to know when a call was made or received. That's the number that made the call, the number that received the call, and the cell phone tower that was utilized during that call, and specifically what date and time that occurred. For cell phone tower, we also need cell phone towers. So, and that would be the location of the tower. And so I'll show in just a second like what cell phone towers, the typical configuration is of a cell phone tower. But a cell phone tower is a tower, but it typically has 3 sides. And that gives us some idea of where in relationship to the tower the phone was, depending upon which side of the tower was used. So those call detail records tell us which side of the tower, typically sector 1, 2, or 3 of a specific tower. And then the tower list tells us which direction those antennas are facing, like north, south, east, or west, so that we can then begin to draw conclusions about where a phone was in relationship to that tower.
Okay.
The design of a tower is typically a 3-sided configuration. And this is just stock imagery of what a typical cell phone tower would look like. And you can see it forms kind of like a triangle. And there's antennas on each side of those triangles. And those antennas are oftentimes adjusted by network engineers will have techs go out and sometimes adjust those antennas a little bit left, a little bit right, a little bit up, a little bit down, canting the antenna or adjusting the elevation of it to provide the best service to an area for the customers for that particular cell phone company. Sometimes cell phone towers can have multiple cell phone companies' equipment on it. Sometimes cell phone companies own their own towers and they have their own equipment on it. But it's not uncommon for us to see when we're looking at records from like T-Mobile, Sprint, and AT&T that 3 different phones are all utilizing the same tower at the same exact latitude and longitude of where that tower exists. Those antennas are directional. So that they're pointing in one direction. If you think about the old TV antenna you used to have on top of a house, and you'd have to point it in the direction of where the signal was coming from so that your TV wasn't fuzzy. These antennas are very much the same. They're directional antennas that all point in different directions. Cell phone networks do have omnidirectional antennas. Those are usually for smaller spaces. For the newer technology that we see today, the 5G technology, we may have omnidirectional antennas that serve a very small area, like a city block, but not major areas with most of these micro cells or macro cells that are much taller antennas that serve a large area, a large geographic area. At the start of a call, when we look at call detail records and we see an incoming call or an outgoing call for a specific device, the way that the tower that's utilized for that call is selected by the cell phone. So if your phone rings, your phone is constantly taking measurements of the signals it hears from all of the neighboring towers. And it goes through a process of what we call stacking and racking. So if your phone hears 5 towers in the area right now, it will begin to stack those 5 towers, and then it'll re-rack them in order of the best quality signal. So if you decide to call the movie theater and see what the movie times are, when you make that call, your phone looks at those measurements and it tells the network that I want to connect to this tower because it's the best quality signal. And after that call is made, if there's network congestion, or if you start driving away from that tower that you're connected to, or the signal becomes weaker or poor quality, then your phone will communicate that to the network, and the network will manage the handoff of your phone to a different tower. But whether it's an incoming call or an outgoing call, the start of the call is always managed by the phone. And that's the best indicator of where a device was, is at the start of the call. I often get asked questions about, well, can't the cell phone tower be full, or push the phone to a different tower? Yeah, towers can be full in extreme situations where there's heavy congestion or a major incident. But most often the best indicator is at the start of a call, which tower was utilized during that activity. And again, the phone will connect to the strongest signal or the best quality signal. And that sector is how we determine where a device was. To further explain that, this would be a bird's eye view looking down on what one of those 3-sided towers look like. So if you're standing over the tower looking down, and we saw that a phone utilized at 5 p.m. on a Tuesday, utilized sector 1 of, say, tower 555, we would look at where that tower is by latitude and longitude. We would look at the tower list and see that sector 1 has an azimuth of 0 degrees. The azimuth is a compass direction. And if it were on the southeast side of the tower and it utilized sector 2 and it had an azimuth of, say, 120 degrees, then we would know it connected to the southeast side of that tower. And if it were on the southwest side of the tower and it utilized sector 3 and that had an azimuth of 240 degrees, then that would be the compass direction, azimuth of 240 degrees. It would be on the southwest side of the tower. We draw sector boundary lines as a matter of standardization and plotting out these records, but these are not definitive lines. It's not like you're standing like right on top of a line and you hop one left foot and then you hop on your right foot, you're going to hit different sectors. There's overlap between these sectors. These are radio signals that are radiating energy. RF, or radio frequency, is energy that's radiating. So this energy radiates, there's overlap between the sectors, and it has to do with what your phone perceives as the best quality signal, and it'll make that determination at that start of the call. I talked about azimuth. Again, we get that from the tower list. So if I see in a call that a phone utilized sector 1 during a call, I look at the tower list and I see an azimuth. This is a protractor, and you can see it's 0 through essentially 360 or 359 degrees. And these are compass directions. So if you see north, south, east, west inlaid inside of the protractor, and then you see, we had a sector that was 180 degrees, that's due south, right? An easier way to think about this is hours on a clock. If you had 30 degrees per hour, then you can think about it like hours on a clock. So if we had an azimuth of, say, 120 degrees, well, 4 o'clock times 30 degrees per hour is 120 degrees. So you can make quick math of it if you think about an hour is 30 degrees. And that just gives you a bearing on north, south, east, or west for the time that a call was made or received based off of the sector utilized. An example of what an actual plot on a map would look like. Again, for instance, say it was Tower 555, and this call utilized Sector 1 with an azimuth of 0 degrees. This is down near Atlanta Police Headquarters, just a few blocks from here. To demonstrate the sector of 0 degrees, I overlay the protractor on the tower. I can demonstrate with a line where 0 degrees is. And then to get those sector boundary lines for 1/3 of that tower, 1/3 of an entire circle is 120 degrees. 120 times 3 makes 360. So to demonstrate a 120-degree side of this tower, I can go 60 degrees to the left and 60 degrees to the right. That's 120 degrees between the two. And I can draw lines emanating from those respective areas out to demonstrate 1/3 or one side or one sector of this tower. When we traditionally look at cell phone records and we say it utilized this side of this tower, I don't know exactly where the phone was within that sector of the tower. I just know that the phone was somewhere on the side of the tower. And that's why I have the phone moving around inside. I can't say this is the butler in the den with the candlestick. I can just say that this phone during this call was somewhere on the north side of this cell phone tower. And the best indication of where that phone was as far as distance to the tower is where the next nearest tower is. Again, because as the phone moved closer to another tower, we would presume that it would get a better quality signal from that next tower. So when we plot records, we include neighboring cell sites so that we can add perspective to the overall analysis. In this case, I did just that. I looked at the neighboring cell sites and I overlaid them on a map, and that includes for Sprint and T-Mobile, because again, Mr. Williams and Mr. Tolbert utilized lines of service that were provided by Sprint or serviced by Sprint, and Ms. LaFleur had a line of service serviced by T-Mobile. And looking at the general Atlanta area, that's the circle of Interstate 285. These are all the Sprint sites in Atlanta. And you can see there's a larger grouping of towers in the downtown area because it's more of a congested area. Also, things like buildings, tall buildings and other structures can get in the way of signals, reducing coverage for certain areas. So having neighboring cell sites, and as you walk down the street, Pryor or Peachtree, you'll see sometimes on top of buildings, low-rise buildings, you'll see cell phone antennas that just face off the side of the building. Those don't provide the same amount of coverage as a 200-foot tall tower, but there are additional cell sites in congested areas to provide better coverage for customers for that service. And then T-Mobile, this is their sites as well. And you can see kind of a consistency between the two, that there's a larger grouping in the downtown area. And then the farther out you go, and the population of customers that would utilize the service is decreased or spread out over a larger area, so do the towers begin to spread out a bit. And in this case, I was asked to take a look at records related to the area of 576 Northside Drive Northwest, specifically for the time period of January 14th, 2019, around 3:31 a.m. So I focused mostly on the time frame between 3 and 4 a.m. for starting with Mr. Williams and Mr. Tolbert. And again, the phone numbers and records that I were provided were for Mr. Tolbert was the 6988 Sprint number, Mr. Williams, the 6092 number, and Ms. LaFleur, the 0733 number. When I looked at Mr. Tolbert, Mr. Williams records for that time period, I found that there was no call or voice activity. I didn't see any call records that showed a number was dialed or that a call was received for either of their phone numbers. But there was data usage and there was timing advance data.
Well, let me ask you this, technically impacted. What does that tell you in terms of, the 3 different categories of call, voice activity, data usage, and time and advanced data? Is it any significance to you that there's no call or voice activity during this period?
No. When I apply my analysis of phone records to criminal investigations, Again, some are as simple as who called whom and when, right? There are some conclusions to be drawn when there's no call activity between two devices, especially if two devices demonstrate tower activity that's consistent with one another and they're moving. If I can plot out a series of towers that are being used by two different devices and it shows that they're moving geographically from one point to another or back to a different location, and there's no call activity between them, it demonstrates, it can be suggestive of the two devices being together immediately next to each other. Because even when my wife and I are driving in two different cars, I may call her or text her to make adjustments to our route, or to say, I'm going to park over here. I'll meet you at this location. I wasn't able to get a parking spot next to you. So if I see calls between two devices and they're moving together, I would suspect that they're not sitting right next to each other. But if I see a lack of activity, it could be suggestive that they were in their immediate presence of one another. It's not definitive. It's just one of the many things that I apply to the analysis of records. And with data usage and timing advance, it's not uncommon to see that. We may see data usage for phones that are at rest. When my phone sits on the nightstand at night, I'm still receiving updates from Instagram and from LinkedIn, and emails are coming in, being delivered to my phone, and that's going to show data usage. Some of that data usage at home may not show up on my call detail records from the phone company because the data is being used through my Wi-Fi router and it's going through a whole different service, and my phone's not necessarily connecting to a cell phone tower for that to happen. But for phones that are not connected to a Wi-Fi and are utilizing the cell services data, that can happen in the background. In addition, if someone has an iPhone and say they're using Apple FaceTime, either voice or video to communicate with one another, that does not go through the traditional cell phone network as a call that would appear in a call detail record report. It would appear as data usage. It's being sent as packet data. And you can think about that like if you're on a Zoom call on a laptop, you're not going through the phone company to dial a number, you're utilizing the internet to communicate with someone face-to-face over a Zoom call or audio call through Zoom or some other application. And the same is true for other applications. Kik, Kakao, Snapchat, Instagram calls, all that would only appear on your phone records as data usage, not as a call detail record. It's a separate type of service that's being utilized for that. In timing advanced data, we do expect to see timing advanced data on phone activity, sometimes even when you're not on a call and you're not actively using data to download emails or get Instagram updates. Timing advanced data is a process of synchronization between a phone and serving cell sites. And sometimes not just the cell site that your phone would select as the strongest signal, but sometimes a group of cell sites that your phone is taking measurements on constantly. It's also the network is trying to determine essentially how far away your phone is from the tower so that they can synchronize the uplink channel that may be utilized to make or receive a call and or to provide data services. It's synchronizing an uplink channel for packet data that's going to be exchanged between the device and the tower. Both the cell phone and the tower are transceivers. The official name of a cell phone tower is a base transceiver station. And transceiver means it transmits signals and it receives signals. It's not just a transmitter like television stations, right? It's actually can receive and transmit data. So for those two to communicate in synchronization, the tower needs to know, the serving tower needs to know, or the equipment on the serving tower needs to know how far away the device is, because how long that signal takes to get to the tower will have an impact on that synchronization. That's some of the engineering data I talked about earlier when we talk about some of the data we didn't understand years ago, but it was existing as a function of the network operating properly. And that timing advanced data is one of those things. We've come to understand it a lot more in recent years, exactly what's going on with that synchronization. And what that tells us is that when a tower sends a signal to a phone and the phone sends it back, there's a round trip time that's traveling at the speed of light. If you travel 60 miles an hour for 1 hour in one direction, and then you travel 60 miles an hour back, we get a round trip, how long it took you to travel 120 miles, right? And we do the same thing with the engineering data, with that timing advanced data. But again, these signals are traveling at the speed of light, and we get an estimate of how far the device was from the tower based off of that round trip time. And what that tells us is you're still on the same sector. We know which sector, which tower you used, which again, we had a wedge for the sector. But now if I know based off of your round trip time with that timing advance data, that you were say 1.2 miles away from the tower, my arm would have represented exactly 1.2 miles. You'd be somewhere along the arc of that sector that's 1.2 miles away, give or take. There's a function called a chip rate. That is the amount of time and space that's covered by a transmission of a packet of data. And it's exactly 78 meters. So we have a 78 meter wide arc that's 1.2 miles away. So you'd be somewhere within that arc. It's possible that you could be closer than that arc, but it's impossible to be further away because you can't really travel faster than the speed of light. So sometimes it takes if there's an additional cable length that's not taken into consideration, it can take longer to process that. But if that were the case, then you would technically be closer, not farther away. So anyway, that's what timing advanced data is. And that goes on in the background all the time. And I've got some plots that I'll show that may help with the demonstration of an aiding in that description of it. But that may go on even when you're not on the phone. And we get not only which tower you were on, but a more accurate location of where you may have been based off of determining how far away from the tower you were, not just this general area that I said, Butler and the dim with the candlestick.
Judge, may we approach briefly?
Okay. All right, Mr. Fawcett, you can continue.
Okay. Now, Detective Leon Packer, you were testifying as to 3 numbers that you were able to identify in connection with this case.
Yes.
And this is from Lead Detective Summer Benton?
Yes.
Okay. And the information that you were analyzing, if we could talk about that specific time frame that you were using, can you tell us about that?
I focused primarily on 3 o'clock a.m. to 4 o'clock a.m.
Okay. And can you tell the court in relationship to this address on Northside Drive, when did we first start seeing Mr. Tolbert and Mr. Williams' phone around that area where the homicide occurred?
Well, it's around 3:15 to 3:30 a.m. There's what appears to be demonstrated movement towards that area. But for Mr. Williams' records, and that's in the next series of actual plotted data in this case. Should I go ahead and proceed?
Yeah, if you could show us those next slides. Sure.
So Mr. Williams' data usage during this time, he had some data that we discard as a matter of analysis because it was timing advanced data without a distance measurement. So we can't verify that data, so we discard it in the analysis. It may provide some better perspective if we could use it, but in this case, for the purposes of conducting a proper analysis that would stand up to scrutiny, this is data usage. The problem with data usage is that you ask for a specific time as to when Mr. Williams' phone began showing activity. You can see on the right side of these plots, there's that location, the pinpoint. That's 576 Northside Drive, the blue pinpoint. And then there's two sides of the same tower that are being utilized in this series of data. All three of these sectors, 2 towers, 3 total sectors, right? 3 total wedges were all logged in as data use records at the exact same time at 3:37 a.m. But what that means, based off of looking at the data usage, which I've just overlaid on the bottom there, this is taken directly from his records. You can see that the last activity before that 3:37 is listed as 8:37 because that's in Greenwich Mean Time or Coordinated Universal Time. We have to subtract 5 hours from that to get Eastern Time, which makes it 3:37 a.m. So we know that this data usage and these towers were utilized sometime between the last data entry for this data session and the next data entry after these towers were utilized. And that gives us a time range that these 3 towers were used. And that's 3:15 a.m. to 3:37 a.m. Looking at Mr. Tolbert's records to continue to answer your question about the time that those records showed activity in the area, overlaying those on this time range of Mr. Williams' records provided some additional perspective. At 3:15 a.m., Mr. Tolbert's device utilized the same cell phone tower that was on the west side here, facing west. That was at 3:15 a.m. And you can see a more lightly shaded arc at the edge of that shaded inset. That's that.
You take it back. If I could have you, since we can all see this, if you're pointing to something and describing, you can actually point.
Sure.
On the screen shows.
So if we were to, this is the record from Mr. Williams' data usage that fell within a time range. And then when we look at Mr. Tolbert's records, his phone utilized the same side of the same tower as Mr. Williams' records, but we get an exact time at 3:15 a.m. And we get the distance, and the distance is between 521 and 599 meters. That's that chip rate 78 meter distance. That's exactly 78 meters. We know it's somewhere within that range. That 78 meter arc is this more lightly shaded area at the edge of this shaded inset. Sometimes the arc will appear outside of the shaded. The shaded inset is just for emphasis, so you can actually see this sector. But sometimes the arc will be farther out and will be more prominent. In this case, it appears to be attached to the shaded inset. And then that's just for emphasis there. At 3:30 a.m., Mr. Tolbert's phone utilized, again, the same sector as Mr. Williams' phone during Mr. Williams' time range, but we know that his phone accessed that southeast side of that tower at 3:30 a.m., and we see a distance of 460 to 538 meters. It's difficult to see, but that arc is also at the edge of the shaded inset.
Now, we're looking at the actual crime scene, the homicide occurred. Can you show us on that graphic where that is?
This is the blue pinpoint that demonstrates, and it's up here in the legend, 576 Northside Drive.
Okay, so that would be where the homicide occurred.
Yes.
What about this location right here? What does that represent?
Looking at a broader range that I didn't plot out, I go back and I verify every single plot that I do. I look at the tower list. I make sure it's correct before I come here before you and testify. But generally speaking, looking at a broader range of records, both records started farther west and we're demonstrating movement to the east towards 576 Northside Drive.
Okay, so farther west, moving towards the area of the homicide.
Yes, that's correct.
All right.
And then I took a range of time and I plotted all of the timing advance data. You can see multiple arcs here demonstrating different distances, but all in this area and all right close to this area of the crime scene. And that's between 3:30 and 3:36 a.m. Mr. Tolbert's timing advance data showed a lot of activity consistent with the area of the crime scene. And remember, these arcs don't just stop. There's a lot of bleed over here, so you can be anywhere along the arc. And you can also be closer than the arc. You can't be further away. So I'd say this data is consistent with being in the immediate vicinity of 576 Northside Drive.
And can you go to the next slide and tell us if we have to determine any additional information?
Immediately following that 3:30 to 3:36 timeframe, I looked at the data for both sets of records. And Mr. Williams' timing advance data began to pick up some additional data that had timing advance measurements. Here you can see a darker inlay shaded area. That's a distance of 234 to 312 meters from the tower at 3:39 a.m. And this is farther away from the crime scene. At the exact same time, Mr. Tolbert's phone utilized a different tower with a different timing advance measurement, but you can see those timing advance arcs overlap, suggesting they were in the same area at the same time at 3:39 a.m. And this is moving away from the crime scene now. Following that, at 3:44 a.m., Mr. Tolbert's phone utilized a different tower, the west side of that tower, and we have the timing advance measurement that now you can see is farther out. With it. It's easier to see the emphasis on that timing advance arc. And just 9 seconds later, Mr. Williams' phone utilized the same side of the same tower, and it's a little bit farther away, which would be consistent with travel during that 9 seconds farther away, and generally the same westward direction. Back to the area from which.
Hold on one second. Hey, Mr. Tolbert, you got to talk more quietly, okay? Court reporter needs to be able to hear the witness. So we're going to be taking a break soon and we can talk then.
Moving westward back to the area from which the devices originally came.
Now, you had three numbers. You had Mr. Williams, Mr. Tolbert, and Ms. LaFleur. What information were you able to determine based on review of Ms. LaFleur's call activity?
The phone records for LaFleur did not have data usage or timing advance records. It was just call detail records. And between midnight and 4:15 a.m., there were only 3 calls. And I was given 874 Center Hill Avenue Northwest as an area of interest. And I utilized that in looking at those 3 calls. And that phone utilized the west side of this tower, very close to that location, for all 3 calls, the same side of the same tower. At 1:40 a.m., there was a call to 678-548-6988. Which is the phone number associated with Mr. Tolbert. And then at 4:14 a.m. and 4:14 and 4:15 a.m., there were 2 calls to 404-831-5446. The first one was only a duration of 9 seconds, and the second 1 minute and 14 seconds.
Okay. So, we're talking about that time frame from 3:15 to 3:37 a.m. This location being Central Hill location. Can you tell us whether or not Mr. Tolbert's and Mr. Williams' phones were in that area during that period of time?
From 3:15 to 3:30?
That's correct.
No, they were not.
Okay. And your testimony is that the phones appear to be coming from the west based off the movement of the map.
Yes.
Okay. Both phones together.
Yes, they appear to be moving together.
Okay. And is that area where the phones are moving from consistent from, say, if they were coming from the location of that Centerville area?
Yes.
Okay. And if we're talking about determining or evidence that is consistent with phones moving together throughout a period of time, is it your testimony that the evidence was consistent with that during that period that you looked at the time of interest?
Yes.
Okay. One moment, Judge. That's all I had, Judge.
Ms. Feely, do you have questions for Detective Leonback?
You kind of touched on this, but the phone would ping off of the tower with the strongest signal, right? Not necessarily the closest.
Correct. When it comes to call activity at the start of a call, not necessarily with per call measurement data, but definitely at the time of a call.
And things like topography can make a difference in the records.
Things like topography can make a difference in the strength or quality of a signal. Yes.
And the number of devices active at the time.
That can have an impact, and we would look for a major incident, like for instance, like a car bomb goes off, or there's a flood or a tornado. Those things could have an impact on network congestion.
And in this particular case, you weren't asked to track any other phones other than these three that you testified to,
That's
right?
correct. Yes.
So you weren't asked to track a Brandon Smith's phone
No.
or a Chatasia Williams's phone.
Yeah, I'm gonna object on relevancy. It's completely irrelevant testimony. I think it's a problem.
Overruled.
Now I want to turn to what you were talking about with the no call, no voice activity.
Yes.
So in this particular case, Mr. Williams's phone did not have any call or voice activity during this period of time.
That's correct.
And you also mentioned that there was in fact data usage.
And I'm sorry, to refine my answer, there's no call activity in the call detail records. So there is data usage. So if there was call activity utilizing other third-party apps, I can't speak to there not being call activity just in these records that I analyzed from the phone carrier, the Sprint. There was no voice call activity.
This is getting back to your point. If I'm understanding, there could have been a FaceTime or a call through, I don't know if you can make phone calls in Snapchat or something, but that could have been happening. That shows up as data usage.
Yes, Your Honor.
But for an old head who would type 2836071, hey, mom, that none of that was going on through Verizon or Sprint or whoever the service provider was.
That's correct.
Okay.
So no evidence then of call or voice activity.
That's correct.
All
Yes.
right. And you talked about data usage, and that happens even when the phone is asleep, right?
You say asleep, you mean like the screen's not active and like someone's not actively using it? Yes, that's correct. That can happen.
And you actually testified that, like, for example, when your wife plugs her phone in at night and goes to sleep in her bed, the phone could still be and is still using data.
Yes.
And these records are, can't tell you if the phone is in somebody's pocket, right?
That's correct.
They're not that pinpointy.
No.
They can't tell if they're in someone else's pocket, for example, right?
That's correct.
You can't tell if the phone was in the center console of the car, right?
That's correct.
Or if it was in the glove box,
That's correct.
or if the phone had fallen in between the seats.
That's correct.
Thank you.
Mr. Francis,
No questions, Your Honor.
any redirect, Mr. Fossett?
In fact, you can tell that that phone wasn't at Center Hill Avenue during those 3 a.m. to 4 a.m., 3:30 periods.
That's correct.
That's all I have, Judge.
Questions from the jurors for the detective? None. Okay. Thank you, sir. Appreciate your time.
Thank you, Your Honor.
So we've got about 10-ish minutes before I need to break. We're having a accountability court graduation across the street, and I have to celebrate someone's graduation. So that's why we're breaking for lunch when we are.
I would anticipate more than 10 minutes, Your Honor.
Okay. Does it make sense to get started, or would it be easier to let this witness go have lunch and then we'll just start after lunch?
I think it makes sense for them to just go to lunch and then come back and.
We're down to 2 witnesses? Okay, excellent. And those will finish pretty quickly after we get back from lunch.
That's correct, Your Honor.
Okay, ladies and gentlemen, you're gonna have a slightly longer lunch break. I'm gonna see if the graduate that I am honoring at the drug court graduation can go first, so that I'll get back here sooner. But it's some other judges as well, and they may have bigger elbows than mine, so they may get to go first. I don't want to disrupt the flow. So what I'm going to do is ask you all to be back here by 1:45. I'll say 1:50, 1:50. And we'll try to get started as close to 1:50 as we can. But I may have made you get back a little bit early. Indulge me. But if I can extract myself, then we'll get started all the sooner with these last 2 witnesses. When the state rests, there's going to be another break. So I was trying to see if we could, and we can't fit it in before lunch because the lawyers and I need to work through several things that arise naturally when the state rests. So if you feel like, dang, Judge, you shortchanged my lunch break a little bit, you'll get some of that time back when we hear Mr. Trepanier say, at this time, the state rests. So any logistical questions from anyone? No outside research. Please don't talk about the case amongst yourselves while you go to lunch. Hit American Deli hard or make it up to that 244 Washington Street, whatever you're going to do. And we'll see you at 150, please. All right, you can be seated, please. Mr. Trepanier, anything we need to talk about before the lunch break?
Nothing from the state at this time, Judge.
Okay. Ms. Feely, anything?
Yeah.
All right. Do you have a sense at this point whether you'll be presenting any evidence? You don't expect to. Okay. In that vein, Mr. Williams, it will be after lunch. So this will be the last time to engage in depth with your lawyers or anyone else. It'll be after lunch, after the state rests, that I'll be having a conversation with you, with your lawyers right here, about whether you want to testify or not. So just be prepared for that exchange and be ready to let me know, yes, I'm going to testify, or no, I'm not. Okay? Mr. Francis, anything we need to talk about before the lunch break?
No.
Okay. Mr. Tolbert, same thing with you. When the state rests, which will happen not all that long after the lunch break is over, we're going to hear from the medical examiner. Who'll talk about how Mr. Fluitt died, got shot in the leg. And it sounds like one GBI witness. After the state rests, I'm gonna have a conversation with you about whether you want to testify. Mr. Francis will be sitting right next to you, but you and I will have that conversation and you'll be telling me on the record whether you want to testify or not. Okay? And if you decide that you want to, then Mr. Francis is going to call. He can't say, no, I'm not going to call you to testify if you decide that you want to testify. Mr. Francis, assuming Mr. Tolbert chooses to testify, do you have other witnesses you would call or just your client?
Just my client.
Okay. All right. Did you have a question? Why don't you ask your lawyer first? Just whisper in his ear first, okay?
It's the other issue that we talked about yesterday that you effectuated yesterday. We need to talk to you about that, I guess, ex parte.
Okay, got it. We'll do that. When you say like you and I will talk, or the three of us would talk? Three of us would talk. Okay, we can do that. What I'm going to do is figure out why they're banging on the door. We good?
Yes.
Okay. I'm gonna ask everyone else to leave. So DA's people be back at 1:45, please. And we should take Mr. Williams where he needs to go. And Ms. Feely and Ms. Wood, if you don't mind stepping outside, you'll be able to come back in a minute. All right. We ready for the defendants?
Yes, Your Honor.
Let's bring them out, please. Do we have all our jurors back? They do not want to ask questions. Ms. Rivers, you ready? All right, we're back on the record in 19 SC 167684, State versus Williams and Tolbert. Mr. Williams is here. Mr. Tolbert is here. Their lawyers are here and our prosecutors are here. Mr. Trepanier, anything we need to cover before the jurors come in?
No, Your Honor.
Your next witness is Dr. Henninger or the GBI person?
Be the GBI interview. We're in session.
Okay. Ms. Feely, anything on behalf of Mr. Williams? And Mr. Francis, anything on behalf of Mr. Tolbert?
No, Your Honor.
Okay, let's bring the jurors in.
All right, jurors. Jurors are present and accounted for.
Thank you, Deputy Gordon. You all can be seated. How was lunch? Very good. Like to hear that. Did anyone make it up to the 244 Washington Street? You did? All right. How's that compared to American Deli?
Better and more affordable.
More affordable. I like the sound of that. Good. And it was a big selection. Good. Not just burgers. Okay. Excellent. Way to go, State Cafeteria. You don't hear that all that often. Thank you for being timely. We had a good accountability court graduation. A number of people made it through the 18 to 24 months, staying drug-free, crime-free, and hopefully are entering a new chapter in their lives. So I appreciate you allowing me to be there for that graduation. We've got a couple more witnesses left, it sounds like, from the state. If you will call your next witness, please, Mr. Trepanier.
State calls Lauren Satcher.
You swear and affirm that the testimony you will give is the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Put your hand on seat. State and spell your name for the record.
My name is Lauren Satcher. That's Lauren Satcher, Satcher.
Good afternoon. Where do you currently work?
I work for the Georgia Bureau of Investigation in the Division of Forensic Science in the Firearms and Tool Mark section.
How long have you worked there?
I started in August of 2020, so almost 3 years.
In your position, what are your roles and responsibilities?
So I'm a firearms examiner. So my main job is looking at ammunition components, so like bullets and cartridge cases, and determining if they were fired in a particular weapon, or if a firearm is not submitted, we can look at them to determine if they were fired in the same weapon and possibly give a list of firearms that could have fired them.
And what is a firearm scientist, and what do firearm scientists do?
So firearm scientist is basically what I just said. You know, we're getting firearms evidence, bullets, cartridge cases, firearms. We'll do check function tests on the guns to make sure they function the way they were designed to. We will look at the bullets and cartridge cases to determine if they were fired in a particular weapon or the same weapon. We'll do other things like serial number restoration, muzzle to target distance determination, and tool mark examinations as well.
And what is tool mark examination?
Tool mark examination is pretty much the same thing as firearms examination, just instead of looking at ammunition components to a gun, you're looking at a tool to tool marks. So think like bolt cutters and a padlock. So it's going to be the same principles. You're just looking at different items.
What educational background and training do you have in tool mark examination and firearm science?
So I have a degree from William Carey University in biology with a chemistry minor. And then I have a master's degree in forensic science from the University of Southern Mississippi.
Are you required to get continuing training in your field?
Yes, so we'll do continuing training. In addition to when I first started at the GBI, I went through about 16 months of training, doing that muzzle to target distance determination, serial number restoration, looking at firearms, how their design, their functioning, ammunition, the design and functioning of ammunition, and then months and months of microscopic examination of bullets and cartridge cases.
Is there a specific methodology that you follow?
So what we're doing is we're using comparison microscopy. And so basically think back to microscopes like you used in high school. And there's two of them that are connected by an optic bridge. So basically that means I can look at two things at the same time. So I can put a test fire bullet on one side and an evidence bullet on the other side, and I can view them both at the same time. So that is the method that we use to determine if those ammunition components were fired in the same firearm.
And is that microscopic examination subject to peer review?
It is. So every case that we work will go through a verification process and a peer review process.
So just explain what peer review is and what verification is.
So verification, so after I would work a case, it would go to verification. What that means is another trained scientist will get that evidence. and then they will examine it the way that I did, not knowing what my results were. They will come to their own conclusion. And then if our conclusions are the same, it will then go to peer review. So the peer reviewer is a third scientist, so not the primary, not the verifier, a third person who will look at the case file, all of the worksheets, all the documentations, all the pictures, to make sure that all of the conclusions that we come to are supported with our documentation.
How many times have you conducted tool mark analysis involving firearm evidence?
I've done over 100 cases, but I don't know the exact number.
Have you been qualified as an expert in the field of firearm science and tool mark examination before?
I have.
Okay. How many times?
6.
Your Honor, at this time, the state moves to tender Lawrence Satcher as an expert in firearm science and tool mark examination.
Ms. Feely, do you want to examine Ms. Satcher in this area? Any objection to having her so qualified? Same questions.
No, Your Honor, no objections to the qualification.
Okay, Ms. Satcher, I will qualify you for the purposes of this trial as an expert in the fields of firearms, words.
Science and tool mark analysis examination.
Firearm science and tool mark examination. Does that seem like the right field?
That sounds right.
Great, that's what it is.
So I want to talk about firearms in general. What's the difference between a semi-automatic firearm versus a revolver?
Okay, so revolver, think back to like your Old West movies, okay? So revolver has multiple chambers that are arranged in a cylinder. And so those will move to come in line with the barrel. During this process, the cartridge cases will stay in the gun and they have to be manually removed, okay? A pistol is also a handgun, but thinks more like James Bond, okay? So that has the magazine, and you'll put the ammunition in the magazine, that'll go into the gun, usually in the grip. And the difference here is pulling the slide back will load the first cartridge into the chamber. And then during the firing process, you pull the trigger, bullet goes down the barrel, and then the slide will recoil. And as it does, it will extract the cartridge case and then eject it out of the gun. So that's the part that's automatically done.
And what happens if a semi-automatic firearm, a pistol, jams? How is that resolved?
So when there is a jam in a semi-automatic, there's a lot of different reasons it could happen, but usually the safest way to resolve it is to drop your ammunition supply, which would be the magazine, and just re-rack that slide to clear that jam.
And would that eject like a live bullet from the firearm?
If the jam occurred, so there's different times where the jam could occur. If it happens as it's trying to feed the bullet into the chamber and then it jams, so that bullet that it was trying to feed is never actually made it into the chamber to be fired, and then pulling that slide back would eject an unfired round. Sometimes the jam can occur when the cartridge case is extracted and then ejected. It can do something we call stovepiping, where it just kind of gets stuck in the ejection port and that jams it, in which case just pulling it back would eject that and load the next cartridge.
So let's talk about cartridge. Is that what I think most people call like a bullet when we talk like people in like everyday terms?
Yes. Okay. So we'll go through a few terms just so we're all on the same page. A cartridge is a single unit of unfired ammunition. Okay. So that's going to be made up of the bullet, the cartridge case, which is what's holding everything, the gunpowder inside, and then on the back, it looks like a little button. It's called the primer. So all of this together makes a cartridge. The bullet goes down the barrel. Cartridge case is what in a semi-automatic pistol would get ejected. The gunpowder is used up, and then the primer is the part that just looks like a little button on the back.
And when you say bullet, is that the projectile? It's the thing it's moving, it's flying, it's going towards something.
Yes. So when I say bullet, I'm talking about the part that actually goes down, the projectile that travels down the barrel and exits the gun.
All right. I want to draw your attention to DOFS case number 2019-1003014. Did you conduct an examination under that case number?
Can I look at my notes?
Yes, and I'm showing opposing counsel has been marked as State's Exhibit 99.
Okay, will you say that case number for me again?
2019-1003014.
Yes.
And who was the listed victim for that case?
Frank Fluid III.
And Exhibit 99 that you're looking at, how do you recognize that?
This is the official report that I generated when I worked this case.
And is that a fair and accurate version of the report that you generated?
Yes.
Your Honor, at this time, the state tenders State's Exhibit 99.
Ms. Feely, any objection to States 99? Mr. Francis?
No, Your Honor.
Admitted.
So as part of your examination, you wrote your report. Is that correct?
Correct.
All right. And does that report include your findings?
It does.
Okay. And did you follow the appropriate methodology and the policies and procedures of the GBI in conducting your examination and writing your report?
I did.
Okay. And was this report peer reviewed and verified prior to it being finalized?
It was.
Okay. So I'm also going to show you that's been previously admitted as State's Exhibit number 88. Do you recognize State's Exhibit 88?
I do.
And what is State's Exhibit 88?
It's a brown bag marked with our DOFS case number and item number.
Okay. And are you aware of what is in that bag?
I am. Would you like me to open it?
Yes, please. So what do you have there in State's Exhibit 88?
Okay. I have 3 smaller envelopes. Do you want me to open these too?
If you just want to let us know what's in each of the envelopes.
Okay. So two of them contain a cartridge case. So remember, that's the part that's holding everything together and gets ejected out of the firearm. So that's what's in 2 of these. And then in one of these is a cartridge. So that's a single unfired unit of ammunition.
And if you want to open them, that would be, let's go ahead and do that now. So let's start with the two cartridge cases that you see. Did you conduct any examination with respect to those cartridge cases?
I did.
And what sort of examination did you do?
Okay, so for these, what I did was, since there was no firearm to compare them to, I compared them to each other. So using that comparison microscope, I mounted one on one side and one on the other. And then I was looking at them at the same time under the scope to determine if they had the same microscopic imperfections, so that I knew that they came from the same firearm.
And in this case, did you reach any conclusion that you memorialized in your report regarding these cartridge cases?
I did.
And what was that conclusion?
These were fired in the same firearm.
Now I want to turn your attention to the cartridge itself. Is there any sort of examination that you conducted on that?
Not on a cartridge itself. We'll have it in our results here, just as saying that we opened it and looked at it just to confirm what it was.
Okay. And just so I'm clear, the cartridge cases, which caliber are those?
They're both 45 auto.
And what about the cartridge itself?
It is also 45 auto.
Close counsel from the states to the 115. Take a look at State's Exhibit 115. Do you recognize that?
I do.
Okay. And how do you recognize that?
It has our DOFS case number, barcode, item number. This is my seal and my initials on the outside envelope, as well as on this inside one.
Would this be 101 on your list? You can use whatever number you want.
It was originally 101, Your Honor, but it needs to become 115.
115 it is, but we're talking about the same.
Same item, yes.
Okay.
And is that the an item that you examined as part of your report in this case?
It was.
Okay, so let's talk about that. What is that?
So this is a bullet. What I have as a 45 caliber bullet.
And I don't believe I did, but Your Honor, the state would tender State's Exhibit 115 into evidence.
I'm following you. I guess 88 was already in, so we're good there. So 115. Any objection to State's 115, Mr. Francis?
No objection, Your Honor.
Ms. Feely? 115 is admitted.
Okay, so tell me a little bit about that and what your examination was.
Okay, so in this case, I only had the one bullet, so nothing to compare it to, no other bullet and no firearm. So what I did was I put this under the microscope and measured what are called class characteristics. And I'm going to go ahead and tell you what the different characteristics are. So class characteristics are things that are determined by the manufacturer. And so they can be in a group of different bullets. So let's just say in the case of a bullet, the class characteristics. Inside the gun, when the firearms manufacturers are deciding how they want to manufacture their gun, they'll put a certain number of lands and grooves, which, if you don't know, on the inside of a gun barrel, there are these grooves that are carved into it, and they're in a spiral. So think of it like putting spin on a football. It makes the projectile spin. So when it leaves the barrel, it has more accuracy. So these grooves inside the barrel are carved into the bullet. So we can determine how many lands and grooves were inside the barrel of the gun by counting the ones that are present on the bullet. These are things that are determined by the manufacturer. They'll determine, do they want it to twist to the left or the right? How many lands and grooves do they want? And then how wide those different lands and grooves are. So since there was nothing to compare this to, I just looked at class characteristics. So how many of those lands and grooves, which direction. I measured the lands and grooves. And then we can put these into what's called a general rifling characteristics database. And it'll take that information and spit out different manufacturers that manufacture weapons with those class characteristics. So for this bullet, that's what I did. I just took those class characteristics and then put them into what we call the GRC to see which manufacturers would make a gun with those specifications.
Okay. And what, I guess, what was the result from that?
I determined that they were consistent. It was consistent with being fired from a Browning, Colt, IMI, Kimber, SIG, Springfield, and Star 45 pistols.
Is that a pretty broad universe of potential pistols? I don't know if there are 10 million types of pistols, and so that's a short list, or that's sort of like saying it could be a Ford or a Chevy or a VW.
I would call it a medium.
Medium
So
list?
9mm is going to be your most common caliber, and so those lists can get really long. For this one, it's a medium list.
Okay.
Going back to the cartridge cases, you indicated that they were fired from the same firearm. Is that correct?
That's correct.
Okay, so that means that whatever firearm there was shot twice. Is that correct?
Yes, so the firearm was shot twice for both of those cartridge cases.
Okay. When it comes to the two items that you have there, the cartridge cases and the projectile, is there any way to compare those?
No, that's not something we do. We can't determine. I assume you're asking if the bullet came out of that particular cartridge case. Yeah, that's not something that we can do.
Without having having the actual firearm, was there any other type of examination that you could have done on these objects that you didn't do?
No.
No further questions, subject to redirect.
Ms. Feely, questions for Ms. Satcher?
Ms. Satcher, the bullet you were testifying about came from the Fulton County Medical Examiner's Office, right?
Yes, correct.
And you could not determine, there were not any unique characteristics that you could even try to develop a possible list of firearms it could have come from. Is that right?
Not for the bullet. The bullet, I did make a list. The cartridge cases did not have unique characteristics.
And then again, the casings, item 2, you said could have been fired from a Browning.
The bullet?
No, switching back over to the cartridge casing now.
Cartridge cases, I was not able to make a list of things that could have fired the cartridge
Got it.
cases.
And then jumping forward to the, and just so we're clear, the cartridges were from the district attorney's office, right?
Submitted by the Fulton County District Attorney, yes.
So then jumping ahead to the bullet, item 2, it could have been fired from a Browning 45.
Correct, that is in my list as a Browning.
Fair to say that's a fairly big gun manufacturer.
Yes,
Same with Colt
yes,
and IMI
yes,
and Kimber
yes,
and SIG
yes,
and Springfield
yes,
and Star.
yes,
And this is not an all-inclusive list.
that is correct.
Now, I noticed that you put on gloves before you handled evidence, right?
Yes,
That's best practices, right?
right.
Because you don't want to contaminate the evidence.
Yes, and I will say we are the last section to get the evidence because we'll be handling it a lot. So it should, if it's getting any other requests done, it'll go to those sections first.
And you wouldn't want to leave like a fingerprint or something on there, right?
I would try not to, but again, if it's supposed to go to fingerprints, it should be there before me because I'm going to be handling it a lot.
Right. And you don't want to leave any DNA on there,
I would rather not.
but that would have happened before you got it, is what you're saying.
Yes.
All right. I don't want to belabor the point, but could you briefly describe to the jury the other tests you would have performed had you gotten a firearm?
So if I did have a firearm, the first thing that I would do is look at the class characteristics of the firearm. So if I have, so in this case, if the bullet had, it had 6 lands and grooves. So if then I had a firearm, I would look at the lands and grooves inside the firearm. If there were 5 lands and grooves inside the firearm, then obviously my 6 lands and grooves on the bullet did not come from that firearm. So you can stop there. So after looking at those class characteristics, if the class characteristics on this evidence is the same as a gun that was submitted, then I will move forward and look at individual characteristics. So these are characteristics that were not intended by the manufacturer, but during the manufacturing process of the firearm, these microscopic imperfections are left behind in the firearm with all this metal on metal interaction as they're putting in those lands and grooves, as they're making the slide of the firearm, it leaves behind microscopic imperfections. And then during the firing process, it is a violent process. And so these microscopic imperfections get imparted onto the softer metal of the bullets or cartridge cases. So if I had a firearm, what I would have done is taken it and test fired it into a water tank. This makes it so that we can recover the bullets and they're still intact. And then I have a representation of the microscopic imperfections in the firearm left behind on the test fires that I know came from that firearm. So then I'll go to my comparison microscope and I'll put the test fire with that I know came from that gun and then the evidence bullet on the other side. And so I can look at them both at the same time to determine if they have the same microscopic imperfections or those individual characteristics. So I can do that for the bullet. I would also do it for the cartridge cases. So again, starting with class characteristics, some firearms, they have a circle firing pin, which a firing pin is the part inside the gun that's going to travel through when you pull the trigger and hit that primer to cause a spark. And it's going to leave an indentation of that firing pin. Some firearm manufacturers have a circle shaped firing pin and others have more of a rectangular shaped. So again, if you have evidence with a circle and a firearm with a square, not the gun. So I would look at those class characteristics, again, determine if they were the same on the firearm as they were on my evidence. And if they were, I could take the test fired cartridge cases and compare them under the microscope to the evidence cartridge cases.
Now, if you got the firearm a week after you got the bullets, you could still do these tests you're talking about, right?
Yes.
If you got it a year later, even those tests would still be valid, right?
Yes, we would still do the same tests.
If you got these today, you could run these tests on the firearm, right?
Yes.
Thank you. No further questions, Your Honor.
Mr. Francis, do you have any questions for Ms. Satcher?
No, I do not, Judge.
Any redirect?
Yeah, Your Honor.
Questions from the jurors? None? Okay. Thank you, Ms. Satcher. I think you came all the way from Savannah. Appreciate that.
Yeah, no problem.
And you can, all that evidence you can leave there. They'll clean that up. You take your gloves and your GBI stuff.
Thank you.
All right, next witness.
The state of Georgia calls Dr. Michael Henniger.
Flip.
Raise your hand. Do you swear or affirm that the testimony you will give will be the truth, whole truth, nothing but the truth, so help you God? Yes. Put your hand on the sheet. Say and spell your name for the record.
My name is Dr. Michael Henniger, and it's spelled Michael and then Heninger.
Good afternoon, Dr. Henniger.
Good afternoon.
Dr. Henniger, at this time, are you currently retired?
Yes, I am.
Okay. Prior to retiring, where were you employed?
I was employed at the Fulton County Medical Examiner's Office
And how long were you employed there?
about 27 and a half years.
And what does the Fulton County Medical Examiner's Office do?
Okay, well, the medical examiner's offices in each county have charge to investigate suspicious deaths that are likely to come to the attention of courts.
And what is a pathologist?
Okay, a pathologist is a subspecialty. Pathology is a subspecialty in medicine. Pathologist is someone who practices that. And pathology is a subspecialty that looks at the appearance of diseases and injuries. It's kind of a visual thing, and so we do either autopsies or some pathologists look at biopsies and fluids, and they often run on laboratories in a hospital.
What is forensic pathology?
Okay, so forensic pathology is a small subset of general pathology, probably only about 5% of it, and we are basically interested in death investigation and mainly doing autopsies.
And tell the jury about your educational background and training in the field of forensic pathology.
Okay, I started out at Utah State University and I received a Bachelor of Science degree in biology. I went to medical school at the University of Utah and I received an MD degree. I went into the military and did an internship in internal medicine at the Keesler Air Force Base in Mississippi, in Biloxi, Mississippi, and I practiced primary care there. After I completed my military service, I went back to Utah and I did a 4-year residency in pathology. And then I went to Minneapolis to the Hennepin County Medical Examiner's Office. I did a 1-year training period, it's called a fellowship in the subspecialty of forensic pathology. After I finished all my training, I came to Atlanta and began to work until basically January of this year.
Are you licensed to practice medicine in Georgia?
Yes.
How long have you been licensed in Georgia?
Since I moved here.
Okay. And what year was that again?
1995.
Are you board certified?
Yes, I am.
Okay. What does it mean to be board certified?
Board certified means that well, there are these boards. One of them is called the American Board of Pathology, and each specialty of medicine has them. These boards set up the criteria to be board certified. They're approved programs that are usually at universities. You have to spend a specific number of months in different areas, and in pathology it tallies up to 4 years. And you have to complete all of these. They're like rotations. And then you have to take a test. It's usually multiple days, and you have to pass the test. And if you complete all of that, then you're board certified.
Do you belong to any professional organizations?
Yes, I belong to the National Association of Medical Examiners. I also belong to the American Academy of Forensic Science. And I didn't stay. I was with the American Medical Association while I was working, but I didn't stay with them when I retired.
Prior to retiring, what was your position at the Fulton County Medical Examiner's Office?
I was one of the associate pathologists.
What duties did you perform in that capacity?
Mainly, we look at the information that is derived from the investigations of the deaths that are reported to us. We do autopsies or other examinations. We determine the cause and manner of death, which goes on its death certificate. And then we prepare reports that communicate our findings at autopsy. And then we communicate our findings to the public, either can be the family members, it can be public health, or it can be courts.
What is an autopsy?
Okay, an autopsy is it's a medical procedure and it's performed on the remains of a deceased individual, and the reason is to determine the cause of death.
How many autopsies have you performed over the course of your career? I
didn't keep count, but I was probably averaging over 250 a year for 27 years, so it's in thousands.
Have you been qualified as an expert in the field of forensic pathology before?
Yes,
Do you know how many times?
I know I've been qualified 10 times since I was retired, and probably hundreds of times before that. I lost track of those.
Your Honor, at this time, the state tenders Dr. Michael Henniger as an expert in the field of forensic pathology.
Ms. Feely, any challenge to that designation? Mr. Francis? Dr. Henniger, you are now 11 for 11. Well, you didn't say you were 10 for 10, but this will be your 11th qualification as an expert in the field of forensic pathology post-retirement.
I think I was counting this one as 10.
Oh, okay. Well, whatever. You're still an expert.
Okay.
When you perform an autopsy, do you document it?
Yes, we do.
And why do you document it?
It's well, I can't actually remember all these cases. I mean, I have no, the day that, like yesterday, I didn't remember this case. And so I have to document it both as in a report where the major findings are written down, and then with photographs so we can actually look at them. So that's crucial for me to prepare to testify as what we saw at the autopsy. It's also crucial for everyone else to look at, and so that we're all on the same page and we're not just saying this and that. I mean, there's something that we have that was created at the time of the autopsy that endures.
And so when an autopsy is performed, do you attach a case number to it?
Yes, every case that we investigate, I mean, some of them we don't do autopsies on, but on January 1st, the first cases we do, we start numbering in, and we give every case a number, and it has the year that the case occurred, and then it has the whichever case it is.
Okay. And did this case have a case number attached?
Okay, this case that we're referring to is case number 19, because it occurred in 2019, and it's case number 0096. So it was the 96th case we looked at, and it was on January 16th.
Did you conduct an autopsy of Frank Fluitt III?
Yes, I did.
Okay, and when?
On January 16th, 2019, at around, started at 9:30 in the morning.
And where did you conduct that autopsy?
At our office, we have an autopsy suite. It's 4 or 5 blocks south of this building.
Do you have normal procedures or policies for conducting an autopsy?
There are basic normal policies and procedures, but then there's also part of the autopsy is tailored to what the case is. So there's kind of it's not just like a robotic thing, but there's certain things we always do, but then there's certain other things that we do depending on the circumstances and the issues that are at hand.
Those procedures and policies that you conduct and are supposed to conduct in all autopsies, did you do that in this case?
Yes.
Okay. Are those procedures that we're talking about procedures that other forensic pathologists follow?
The basic ones, most people follow them, and then there's the ones that are more according to your discretion. There might be variations in different pathologists the way that they do those.
Are autopsies common and their findings generally accepted in the medical community?
Yes, definitely.
With respect to Mr. Frank Fluitt III, what condition did you receive his body in?
Okay, he came to us in a big black disaster bag, and he had previously, after he died, he'd undergone some tissue donation, which is common if they're eligible for that and if the families agree to it. So that had taken place before the autopsy. So they had removed his clothing, and there was some personal effects. And then, so basically he was in that condition.
Can you explain to the jury what cause and manner of death is?
Okay, cause of death is, I think of that as kind of like chapters in textbooks in medicine. Like there might be a chapter on heart disease or on heart attack or like pneumonia or seizures or things like that. So those are causes of death. There are things that happen in the body that prevent it from continuing to function, and to be alive. Then a manner of death is a word that we use in a special way. And we look at the autopsy and we look at the circumstances around the autopsy, and we try and categorize the death into one of four boxes, and these are natural deaths, which are due to things that happen inside the body, diseases mostly. And then there are accidental deaths, which are things that happen to the body from the outside in the environment that are not intended. And then there are suicides, which are inflicted injuries by the person upon themselves. And then there are homicides, which are inflicted injuries upon a person by someone else. So those are the four main categories. And there's a fifth one that's called undetermined. And those are when we can't easily put them into one of the other categories. So when we say manner of death, we're going through that process. It's not just, we're kind of saying, what was the manner? It has a common usage that we're doing it a little bit different than that.
In this case, what was the cause of death?
Cause of death was a gunshot wound on his thigh that went up into his pelvis.
And what was his manner of death?
The manner of death, which based on circumstances, was a homicide.
When you conduct the autopsy, are photos taken?
Yes.
I'm going to show you what I've marked as States Exhibits 101 through 111, previously shown to council.
Okay.
Do you recognize States Exhibits 101 to 111?
Yes, I do.
How do you recognize them?
Well, first of all, they have this number that we referred to earlier, this 19-0096. They're labeled with that number. And then they basically are pictures I've seen earlier. And then they also are consistent with what's in the report that I have.
Okay. And are those fair and accurate representations of any of the pictures that were taken during Mr. Fluid III's autopsy?
Yes.
Your Honor, at this time, the state would tender States Exhibits 101 through 111.
Ms. Feely, any objection? Mr. Francis? They're admitted.
All right. And Your Honor, the state is going to be publishing the medical examiner photos at this time.
All right.
So we're looking at States Exhibit 101. What are we looking at in this photo?
Okay, in the background is the disaster bag. And there's this tag on it. We used to call this the toe tag before when we just put them on people's toes, but now they go on the bag. And it has a person's name on it. It's got that accession number 19-0096. It has this seal, this red seal, and that seal's fastened to this tag and then put on the body bag so that we keep it secure. In this case, it was just been broken during the tissue donation.
I'm going to show you States Exhibit 102. Looking at States Exhibit 102, what are we looking at?
Okay, this is probably the first picture we take right after we open up the bag. Then we basically take a picture of what's in the bag. And so we see him, his clothing's been removed some of the incisions on his arms and legs are from tissue donation or long bone donation. There's some other medical intervention that's still on his face. And then the hospital tried to help us out by putting bags around his hands to try and preserve trace evidence. And we usually use paper bags, but apparently they didn't have paper bags. You know, this is the emergency room where they're not really focused on this kind of thing anyway. So they did put some plastic bags on his hand, taped them up.
I'm gonna show you State's Exhibit 103. What are we looking at in this photo?
Okay, this is a picture we took of basically his head, and it documents the mask that's on him that was where the breathing tube is attached, and it also has that accession number with it, so that we can identify him with that number.
Show you State's Exhibit 104. What is this?
Okay, this is a similar picture, and this one, it's kind of similar to the previous one. This is a kind of standard picture. We call it the identification photo, and it has the accession number on it, a picture of his face, and it is mainly, its purpose is to remind us that this is a person and not just a little project that we have, and to kind of humanize him.
Did in looking at this photo, did Mr. Fluid have any injuries to his face that you were able to observe?
He had two small injuries that are visible, and if I may, I'll just point them.
If you want to stand up and point them out.
One's on his nose right here. One's under his right eye. These are minor abrasions.
What would those injuries be consistent with?
They could be consistent with many things. They could be consistent with a fight or some kind of altercation. They could be consistent with him running into something. Sometimes when people die, they fall on their head. It's usually on the more exposed areas. The one that's on his nose is kind of down inside the bridge of the nose. So I don't think it's from falling unless he fell on a rough surface. There's a variety of things. They're fairly non-specific.
Now I'm showing you State's Exhibit 105. What are we looking at in this photo?
Okay, so this is a picture of his ear. It has an earring in it, and there's not one on the other side. And the main reason we take pictures of these is because this jewelry can sometimes be expensive and be worth a lot. And when it's being moved from a hospital to LifeLink, from tissue donation to our office, things disappear. And so we take these pictures to try and, it's partly to keep track of the jewelry that we have, that we see and that we turn over to the family versus what, sometimes, if it's missing before we get it, then we can't do anything about it. But this lets us know that we had that earring. And then sometimes it proves to be useful in other ways.
And you already mentioned it, but was there an earring like that in his other ear?
No.
Now I'm showing you what's been marked as State's Exhibit 106. So what do we see in this photo?
Okay, this is his knees right here. And you can see his stomach He's a pretty large guy. And you can see down here, there's this little white stripe. That's a tag. It's got a ruler on it. It's 2 inches. And it's also got his accession number on it. Just below that tag, towards his feet, there's a round spot that's red. That is a gunshot entrance wound that's there. And this is the best picture that shows the location of this gunshot wound. It's also the best one for visualizing where it went. And this gunshot wound went up through his thigh, into this area, femoral area, and continued into his abdomen. So that's the direction of that gunshot wound. It's hard to, all the other pictures, it's hard to visualize that, but this one you can see it. So and that's with him in this position. I don't know what position he's in when he's shot. He could be in a lot of different positions when he's shot.
I'm showing you State's Exhibit 107. So what is this photo of?
This is a little bit closer picture of the previous one. And we tend to start out kind of from far away so you can see where it is. As you get closer, you see the wound better, but it's harder to tell where it's at. And if you didn't know, you might think that's on his stomach or somewhere, but it's the same picture. Oh, excuse me, not the same picture. It's the same wound that's in the picture.
And looking at State's Exhibit 108 and 109 in front of you physically, what are those photos of?
These two pictures?
I was gonna say, the ones that you have physically in front of you?
Okay, these. These aren't numbered.
Oh.
Oh, I'm sorry. Okay, these are the ones I looked at before coming in the room. These are the ones that I was given a minute ago. Sorry about that. So 108. And
what are 108 and 109?
Okay. Okay, 108 is an even closer up picture of it. And it's like, the tag is like almost half the size of the picture. So it's really close up. And this picture is important because it shows the features of an entrance wound.
Okay.
It's not an exit wound. Now, it has a bullet at the other end of it, so that's not too surprising. But sometimes that's how we tell entrances from exits, is the appearance.
Okay, and this is State's Exhibit 108?
Yes. So this is this entrance wound. It's got a little abrasion around it. That's how I know it's an entrance wound. That's characteristic of entrance wounds.
And what about State's Exhibit 109?
109 is similar picture from a slightly different angle. It shows the abrasion a little bit better.
Okay.
Also, we try and clean the blood off of these injuries because they can be confusing and sometimes they're not always successful. But this second one has got the blood is cleaned off of it.
Showing you State's Exhibit 110. What is this?
Okay, this is a close-up of his groin area. And you can see a little bit of pubic hair here. His feet are down there. His abdomen is up here. And this has these big holes in it. And his femoral artery is right there, which sometimes if you've had medical procedures, they'll get blood from there. And it's where that's a big artery that's close to the surface. And the bullet went through this area underneath the skin and it disrupted the femoral artery. And these holes that could either be medical intervention from big needles or somehow like where the skin stretched or for some other reason. I don't really know exactly what caused these holes. They're close to the wound pathway, but they are also close to where medical intervention occurred. And of course, when I'm doing this case, especially early on. And I'm wondering, are they gunshot wounds? And so one of the things I looked at was, does this make sense for more gunshot wounds? Because this one's kind of, they're both too small really, but this one's pretty, this one you can maybe imagine, but I don't think they are. They don't have pathways. There's no bullets associated with them. So they are injuries, and I'm not sure whether they're medically related or whether they're related to the pathway of the bullet.
Now I'm showing what is marked as State's Exhibit 111. What is this?
Okay, so this is what I found in his inside of his body, down in his pelvic area. Because that artery was transected, there's a huge amount of blood associated with that, and it's around the area of the artery, but it's also where this bullet went into his abdomen. It made a pathway through soft tissue, and the blood can get into his abdomen. So there's a lot of blood in his abdomen. And this bullet's just kind of moving around freely in there as we move him from off the gurney. So I don't know exactly where it terminated, but it's in his abdomen, and it's kind of deformed. It's got the top of it's kind of folded down on the sides.
Can you describe Mr. Fluid in terms of his age, height, and weight?
Yes, my notes, so I get this. Okay,
And I guess before we do that, did you generate a report of your findings in this case?
Yes, I did.
Okay, I'm showing what's been marked as State's Exhibit 100. You recognize State's Exhibit 100?
Yes, I do.
Okay, what is State's Exhibit 100?
This is a copy of my autopsy report. It's similar to one here, and has on the last page, has this little stamp that says, "I hereby certify this document to be a true and correct copy of the record on file in Fulton County Medical Examiner's Office." And it's signed by the custodian of records, which is a person in our office. This is one of the things that they do, is they issue these reports and they stamp on this being authentic coming from our office.
Your Honor, at this time, the state would tender State's Exhibit 100 in evidence.
Excuse me. Mr. Francis, any objection to State's 100?
No objection.
Ms. Feely?
No.
Admitted?
So can you describe Mr. Fluid in terms of age, height, and weight?
Okay, so we were told he was 28 years old, and he appeared to be consistent with that. He was 68 inches tall, which is 5'8", and he was 264 pounds.
You've mentioned this already, but when you conducted the autopsy of Mr. Fluid, what signs of medical intervention did you see?
Okay, the ones that we saw were, one, there was a tube that went into his throat to help him breathe. It's endotracheal tube, and that's often common. There was also one that went from his mouth into his stomach, and that's in case they have to drain material out of his stomach. If the bullet, when they're putting these tubes in, they don't know where the bullet is what it's done. And so that, it could go through his stomach, so they'd want a tube to get the gastric contents out. And then he had incision under his left breast here. And this is a heroic thing that they do when people are just right at the very end of the battle for their life. And they'll cut them open and try and literally squeeze their heart, so it keep beating a little bit longer until they maybe can do something. And then there was one EKG pad on his abdomen. I presume there were a lot more than that. Those either fall off. He had punctures in his arms on both sides with bruises where they could draw blood. He had an oxygen monitoring device on his index finger, so they tell how much oxygen's in his blood. And then they had an identification badge, or not badge, a band on his arm, but it just had hospital information on it. It didn't have his name on it. But at least we have that to compare if his identification is an issue.
Do you take X-rays before you conduct an autopsy?
Yes, we do.
Okay. Did you observe anything notable in the X-ray in this case?
The main thing that I was interested in, especially since I'm not a radiologist and can tell all the nuances of the diseases, but I'm mainly interested in the bullets because they're really visible. Lead blocks all the X-rays, so it shows up. And so that's how we can find bullets, and also how we can make sure that we found all the bullets is, we use X-rays.
I'm showing you what has been previously admitted in evidence of State's Exhibit 115. Can you just take a look at that?
Okay.
Do you recognize State's Exhibit 115?
Yes, I do.
How do you recognize it?
Okay, well, first of all, it's in these funny little plastic boxes, and this is kind of unique to us and our office, and this is what we do with our bullets. I've never seen a box quite like this. I'm sure somebody probably has, and then it's got our red tag with my handwriting and my initials on it with the date. This is the same date as the autopsy. It's got this sticker that's similar to some of the other stickers that we've seen. It's got his name and his session number. And then it's got this bullet in it, this round projectile. When I saw it in our picture, there were these leaflets on it that have been kind of folded down on the sides, and they were flat down on the sides. They've been pulled up so they can see the sides better by somebody else, probably the people who examine bullets. So that they've kind of pulled the leaflets back up off the side, so it's now kind of like it's like a big flower or something. But this is the bullet that came out of his body, and it's also labeled pelvis with my initials.
Did you observe, you mentioned when we were looking at the photos that you observed a gunshot wound. Was that the only gunshot wound that you observed?
That's the only gunshot wound that I observed.
Okay. Can you kind of describe that gunshot wound as you summarized in your findings?
Okay, well, that gunshot wound was an entrance wound. It went up through his, I described it going up through the muscles of his left thigh. And then it went through the femoral artery. And then it went into the lower peritoneal cavity. And that's as far as it went.
Can you, when you look and do these sorts of autopsies, do you have any sort of directionality that you can tell from that?
Yes, what we do for that, because the problem with that is I don't know what position he was in when he was shot. It could be a lot. So I put him in my mind, I put him in a standard position. And this is the position that we learned in anatomy class. When you take anatomy, it's the whole medical school, So these are usually thinking about people being alive and standing up. So there's this standard anatomic position that we imagine people being in, and that is them standing, straight up, and then they put their hands like this because these bones, if you put them like this, they're cross. So to try, I don't know, somebody thought this was the best way to think of anatomic position. So I put him in this anatomic position. Okay, and then my directions I describe based on that. So they're very clear from in that position. Then if we want to think about him in being in other positions, then we don't get lost. Okay, so if we put him in an anatomic position, this bullet is coming from the back of his leg, slightly forward, up into his abdomen. It's coming from his left to his right, and it's coming up steeply. So if you had him standing, he's standing like this, I mean like up like this.
What are soot and stippling?
Soot and stippling are things that come out at the end of a gun, and they get deposited on the skin of a person or on targets or objects, and they only are thrown out of the gun a few feet. So if you see soot or stippling, then the muzzle of the gun is close to the target or the body. If it's all concentrated in a little tiny area, it's a contact wound. Soot is particulate matter that's from burnt gunpowder. It can wash off. So in a case like this where he's been lifelink into the emergency room. It's hard to find it even under good conditions. Stippling does not wash off. Stippling are actually little pinpoint injuries from pieces of gunpowder that hasn't quite burned, that prick the skin. And that does not wash off. And if the person survives hours to a day, actually there's inflammatory reaction to it. So it actually is easier to see. Okay, he didn't have either one of these. So the distance from the gunshot wound to the muzzle of the gun is more than a few feet.
What sort of injuries did the gunshot cause?
It disrupted, the main thing it did is disrupt the artery that goes to his leg, the femoral artery. And then it also disrupted some of the muscles in his leg.
And do you examine both internally and externally?
Yes.
What internally did you see in reference to that injury?
Okay, this got into his abdominal cavity, which that kind of makes it a different kind of wound. If you get a gunshot wound that just goes in your skin and a couple of muscles, that's usually not going to be a problem. Once things start getting into the abdominal cavity, they take things with it, like bacteria or blood, and then they can cause problems. So that's going to mean you're going to end up with an operation at the minimum. And then if he's bleeding to death from it, it's not uncommon that when you get gunshot wounds into the body cavities that you're going to have problems. Before the antibiotic era, thinking back to the Civil War or the World War I, a shot into the abdomen is fatal most of the time because it just causes too much problems. So we saw blood in his abdomen. The bullet had gone through a lot of tissue by that point, and so it didn't have very much energy left. And so when it seems it's kind of odd, but when bullets are going slower, they often sort of don't go through the bowel. The bowel's kind of slippery and spongy. So a lot of times you'll see wound tracks through the abdomen, but the bowel is not damaged. So it may have passed close to his bowel, but it didn't damage it.
Apart from the gunshot wound that we discussed, was there any other sign of acute injury?
Just the two minor injuries on his face that we saw earlier.
What caused Mr. Fluitt to die?
Okay, he bled to death from this gunshot wound, and it's from the artery that was transected.
When someone is bleeding to death, would they, as you understand it, would they have trouble breathing or feel like they were having trouble breathing?
Okay, the body's kind of designed to withstand some blood loss and to keep functioning. So at the beginning, he's probably, it may hurt quite a bit. It may put him kind of into shock, or there can be emotional, oh my gosh, sort of things that would incapacitate him. But he's physically capable of doing quite a bit for a few minutes. But within a few minutes, he's going to start losing blood. He's going to get weak. Eventually, he's going to pass out. He may feel short of breath because he's not getting enough oxygen to his tissues. And then if that blood isn't replenished, then his brain doesn't get enough oxygen. His brain stops functioning, and his heart and other organs kind of in turn, and that's the death process.
No further questions, subject to redirect.
Ms. Feely, do you have questions for Dr. Henninger?
Questions, thank you, Doctor.
Mr. Francis?
Your Honor, I do have a request for a bathroom break.
We're going to do that in a second. I think we're going to have a longer than brief break in just a moment. Jurors, do you have any questions for Dr. Henninger? No? Okay. May Dr. Henninger step down?
Yes, sir. Dr. Henninger may be excused.
Thank you, sir, for your time. Appreciate it. Good seeing you. Hope you're enjoying retirement. You take your stuff, leave behind our stuff. Thank you. Mr. Trepanier, your next witness.
Just one moment, Your Honor. Ms. Feely and I are conversing regarding one outstanding issue.
Okay. We can work through if things need to be redacted or whatnot. If we're talking about, I don't have numbers for the exhibits, but proof relative to counts 9 and 10? Okay. We're going to take a break. I'm sorry you couldn't get that together in time, but ladies and gentlemen, I have you step outside. You may come back real quickly to then go back for a longer break, but we need to take a restroom break right now. All right, we'll get other things on the record. Let's get our defendants to their break, please. Can you, over the break, sort out whatever you need to sort out?
We have it, one written out, Your Honor. It's just, we're just making sure that's appropriate in this meeting.
Okay. This is a short break. Once we needed to take it, that's fine. But once Mr. Tolbert and Mr. Williams are ready to go forward, I'm not leaving, in fact. We're just, when Mr. Tolbert can come back, we're gonna get back in. Okay, Ms. Rivers, we're back on the record. Mr. Trepanier, tell me what's going on.
So Ms. Feely and I were working on a stipulation for the certified convictions. I believe we've reached a stipulation that the defendant, Ramel Williams, is a convicted felon for purposes of counts 4, 5, 9, and 10 of the state's indictment.
And then you'll tender the convictions. They may not go out with the jury. We can work through that later, but they certainly need to be made part of the record. And those convictions correspond with the specific case numbers that are listed in counts 9 and 10.
That's correct, Judge. State's Exhibit 112 would be the people of the state of Illinois versus Ramel Williams, number 09CR1423302. And State's Exhibit 113 is people of the state of Illinois versus Ramel Williams, number 14CR2198801, certified statement of conviction disposition in those cases.
Okay, so you will, in front of the jury, tender those. I'll admit them, but there's also a stipulation that for purposes of 4, 5, 9, and 10 counts, Mr. Williams is a convicted felon, if I got the correct counts. You'll read whatever you're going to read into the record.
Yes, Judge.
Okay, Ms. Feely, does that comport with your understanding? Any issues with that? Mr. Francis?
No.
And then, Mr. Trepanier, you are resting?
Yes, Judge.
Okay, let's bring the jury out for that 30-second event. Pull back out. Okay.
All right, for the jury. Judge, the president accounted for.
Thank you, Deputy Gordon. Let me click that. There we go. Okay. Mr. Trepanier, if you would please call your next witness. Mr. Fossett.
Yes, Your Honor. Your Honor, at this time, the state will move to tender 2 exhibits into evidence at this time.
Okay.
The first exhibit is State's Exhibit 112. That is a conviction out of the state of Illinois, the clerk of the Circuit Court of Cook County. That indictment is 09CR1423302. The second conviction is State's Exhibit 113. It's also out of the state of Illinois, clerk of the Circuit Court for Cook County. That indictment is 14CR2198801. So I will tender those into evidence at this time.
Okay. Any objection, Mr. Francis, to the admission of states 112 and 113? Ms. Feely?
No.
Okay, they are admitted.
And I have an additional matter to read into the record with the court's permission.
If it's what we just discussed while the jury was out, you have my permission.
Thank you, Judge. Your Honor, the defendant, Ramel Williams, and the state have entered into a stipulated agreement we would like to announce to the jury at this time. And that is that the defendant, Ramel Williams, is a convicted felon for purposes of counts 4, 5, 9, and 10 of the state's indictment.
Okay. Any issue with that stipulation as it was read into the record, Ms. Feely?
No.
Mr. Francis? Okay. That is stipulated to. We'll talk about what that means when I give you the charge at the end, but it sort of simplifies a couple things you need to work through during your deliberations. Mr. Trepanier, any other witnesses?
Your Honor, at this time, the state rests.
Okay, ladies and gentlemen, the state's case is closed. You have received all the evidence of the state's case in chief. I refer to it as the state's case in chief because it's possible, if either defendant puts on any evidence, that when that defendant rests, the state would ask to put on rebuttal evidence, something in response to what we hear if either defendant puts on a case. Neither defendant has any burden, neither defendant has to put any evidence up. But if one or both choose to do so, I will be asking the state if they have any other evidence they want to put in. But their case is closed right now unless a defendant chooses to put on evidence and then the state wants to put on rebuttal evidence. We are at a natural break point now. I know you just had a break, but that was because we needed to take a break. Now we have to take a break because I have to work through a couple legal issues that naturally arise when the state rests. I will do that as expeditiously as I can, and we'll bring you back out here to get on the record the announcement from Ms. Feely as to whether Mr. Williams is putting up any evidence through her, and then the announcement from Mr. Francis about the same thing, but on behalf of Mr. Tolbert. It's not yet time to deliberate. While you have heard the state's case, you haven't heard any evidence from the defense if they're going to put any up, and you also have not received my charge to you or the closings from the lawyers. So enjoy the break. Don't talk about the case. No outside research. We'll get you out here as quickly as we can. Thank you.
All right, adjourn.
All right. Ms. Feely, any motions at this time?
Commissioner, we would move for a directed verdict on the indictment. All 10 counts, as all 10 counts, I misspoke in opening, all 10 of them say the word handgun, and there was not a handgun presented as evidence in this case, and there was no testimony at all that Mr. Williams at any point possessed a firearm. So we would ask the court to direct verdict.
Okay. I'll let the state address that. Let me turn to Mr. Francis to see if he has any motions at this time. No motions. Okay, so we have a motion for directed verdict on behalf of Mr. Williams as to counts 1 through 10 based on handgun being effectively an element that needs to be proven. The murder and everything that flows from it involve allegations that there was a handgun. The armed robbery, let me find the armed robbery, by use of a handgun, the aggravated assault, the deadly weapon was a handgun. So handgun everywhere in there. Mr. Trepanier, are you handling that or is it Mr. Fawcett?
I'll be handling that, Your Honor. What we have are 1 gunshot wounds. We have a projectile. We have shell casings, which the GBI report indicated a list of 45 caliber firearms, and also indicated she was talking about pistols or handguns. So the GBI report as well. We have evidence of a firearm being used, namely Mr. Brian Wiley testifying that he heard a gunshot, but Mr. Wiley didn't say that he saw a long gun or anything alike. So there, Your Honor, the state would ask that you deny defense's motion at this time.
I don't recall enough of the specifics of Ms. Satcher's testimony or what's in her report. Did it list handguns as the likely origin of the shell casings, or was it simply acknowledging it's a 45 caliber shell casing and any Browning firearm, long gun or handgun, could have left the tool marks that were on those shell casings?
I believe it says microscopic examination of the bullet. Item 2 reveals that it's consistent.
So that's bullet.
With being fired. from-
I'm asking about the shell casings. You can get to the bullet. I'm asking about the shell casings.
No, the shell casings do not say that.
What does it say?
It says they did not reveal any unique characteristics that could be used to develop a list of possible firearms in which they were fired.
Okay, so shell casings, she's simply able to say from the same? The two shell
Yes,
casings,
2 shell casings would have been fired from the same firearm.
firearm, but she can't say beyond the word firearm that it's a Browning or that it's I guess she knows the caliber because the shell casing, it's a 45 caliber shell casing.
Yes, Judge.
Okay, but nothing about a specific make, model, anything like that for the shell casings.
That's correct, Judge.
Okay, and then the live round, it's just a live round, but it's 45 caliber.
That's correct.
Okay, now the bullet.
The bullet says microscopic examination of the bullet. Item 2 reveals that it's consistent with being fired from Browning, Colt, IMI, Kimber, SIG, Springfield, and Star 45 pistols.
Okay. All right. So Mr. Williams, the motion your lawyer made is timely and appropriate, and this is when I ought to hear it. It's a tough motion to get granted because the standard that I have to apply is if there is any evidence, not some or a lot, but any evidence in the record upon which a guilty verdict could be supported, then the defendant is not entitled to a directed verdict of acquittal. It is a significant remedy that Ms. Feely is seeking. It takes from the jury their ability to decide guilty or not guilty. But if I find that if I take the evidence in the light most favorable to the state, that a jury could beyond a reasonable doubt find you guilty. Not that they will or that they should, but that they could. I'm directed by the appellate courts to deny the motion. And I think that a jury could, based on what they've heard so far. So nothing that follows, but what they've heard so far, Mr. Wiley saying there was a struggle over an object and he demonstrated that sort of fits in 4 hands struggling over something. So not a long gun. And then what we heard about in particular, not just shell casings or the live round, but the projectile, the bullet that was taken from Mr. Flewitt's body, found in his body, and that came from a pistol, i.e. a handgun, and not a long gun. So is that sufficiently persuasive for a jury? Don't know. But the whole point of this analysis is that a jury could conclude that it was a handgun based on what they've heard so far. And they're not required to find that it is a long gun. And so I'm going to deny the motion for directed verdict. Which brings us next to the conversation that I previewed. I want to start with Mr. Williams. Mr. Williams, do you understand that you have a right to testify and that if you want to testify, no one can prevent you from doing so?
Yeah.
Okay. Do you understand that in the same way, no one can compel you or force you to testify? In other words, you've got an equal right not to testify if that's your choice. Yes? Okay. Do you understand that it is you and not your lawyer who must ultimately decide whether you're going to testify? Do you understand that if you choose not to testify, I will tell the jury in my formal instructions to them at the end of the trial that that decision cannot be used against you in any way? Do you understand that if you choose to testify, you will face direct examination from your lawyer? Those are typically the easier questions, but you also will be subject to cross-examination by Mr. Francis and by one of the 2 prosecutors. Do you understand that? And you wouldn't get to skip some questions because they're hard or difficult or awkward. If they're objectionable, Ms. Feely could object, but you don't get to say, that question I'm not going to answer. You understand that? Okay. Understanding those things, Mr. Williams, do you wish to testify in your trial? Okay. I find that Mr. Williams has made his decision not to testify with a full understanding of his rights and the consequences of choosing to testify versus not testify. And I will instruct the jury at the end of this trial that they should draw no conclusions that are adverse or harmful or anything like that because you elected not to testify. Mr. Tolbert, do you understand that you have a right to testify and that if you want to testify, no one can prevent you from doing so?
Yes.
Do you understand that in the same way, no one can force you or compel you to testify if you do not want to testify?
Yes.
Do you understand that you and not Mr. Francis will be telling me whether you want to testify or not?
Yes.
Do you understand that if you choose not to testify, I will explain to the jury that they may not draw any hurtful or harmful influence or inference about that decision to not testify? Do you understand that if you choose to testify, you will be first questioned by your lawyer, Mr. Francis, but then you'll be cross-examined, or you may be cross-examined by both Ms. Feely and one of the prosecutors. And you'll need to answer all their legal questions. So Mr. Francis can object to, and I'll sustain the objection if it's an improper question. But if it's a difficult one, it's an awkward one, you still need to answer those. You don't get to say no, thank you. You got it? Okay. Understanding all the things you've told me you understand, Mr. Tolbert, do you wish to testify in your case? Okay. And you've had enough time to think about that. All right. I find that Mr. Tolbert has made the decision not to testify with a full understanding of his rights. Ms. Feely, do you plan on calling any witnesses?
No.
Mr. Francis?
No, you.
Okay. Then what's going to happen when the jurors come back in is I will start with Ms. Feely and ask if you're going to be presenting any evidence. You'll say what you're going to say. And then assuming you say the defense for Mr. Williams rests, then I'll turn to Mr. Francis. And Mr. Francis is going to say something similar, but it'll be the defense for Mr. Tolbert rests. And then I'm going to send the jurors home because we need to have our charge conference. And I don't want to have them sit around. And even if they did sit around, we'd get a little bit into closings and not very far. So they'll be here tomorrow. We cannot start tomorrow until 9:30. So I'll have them show up at 9:30. And we'll start with the state's closing unless the state is reserving everything for rebuttal. Anything else, Mr. Trepanier, before I bring the jurors in?
No, Your Honor.
Okay. Anything else, Ms. Feely? Mr. Francis?
No, you.
Okay.
All right, the jurors.
Warning here to you. It feels like it's because someone messed with that monitor.
I'll do the president accounted for.
Thank you, Deputy Gordon. Everyone can be seated. Ms. Feely, are you going to be presenting any evidence on behalf of Mr. Williams?
On behalf of Mr. Williams, our defense reps.
All right. Mr. Francis, will you be presenting any evidence on behalf of Mr. Tolbert?
No, we will rest at this time.
All right. Ladies and gentlemen, there is no rebuttal from the state because both defendants elected not to present any evidence during their phase. They had no obligation to do so. And now I can tell you that the record is officially closed. You've heard all the evidence you're going to receive. We're done today as a group. What's next is that I need to have about a half-hour conversation with the lawyers and their clients about the law that I need to give you at the end of all this. And so I could keep you here for a half hour. You'd come out and we'd get a little ways into closing arguments, and then we'd have to stop. We wouldn't probably get through the first part of the state's closing. So I made the executive decision of saying, we will cut you loose for now. Tomorrow, we cannot start till 9:30. So please be here by 9:30. Get here as early as you want. All the wonderful supplies will be there, but we will start up at 9:30, and we will start with closing arguments. That's when the lawyers argue to you what they think the evidence has shown or failed to show. Because the state has the burden of proof, they have the ability to go first and last. And Mr. Trepanier will let me know in the morning whether he's going to take both pieces and talk to you for a little while and then get out of the way. And then Ms. Feely and Mr. Francis will have a chance to go. And then the state gets a chance to have the final word. That's what we'll do in the morning. That'll fill most of the morning. When the lawyers are done with their closing arguments, I'll give you the charge, the law that you must apply, and then you'll begin your deliberations. So you will get this case to begin your deliberations at some point tomorrow, before lunch, after lunch, TBD, depends how long all the closings take. Tonight, please don't engage in any outside research. You now have all the evidence you're going to get. If that wasn't enough evidence, then it wasn't enough. And you let us know that when you're done deliberating. If it was enough for you to reach a verdict, then you're going to be able to do that. But you may not supplement the evidence that you received by researching or talking with other people about this. Have a good, slightly longer afternoon than you were going to get. Any logistical questions before you follow Deputy Gordon out? Take your pads with you, but leave your pads in the jury room. And we'll see you before 9:30 tomorrow. Thank you so much.
All right, the jury.
You all can be seated. I'm going to have the dream folks. Does it seem warm in here? You mean you even took your jacket off? Okay, something has changed. All right, give me a second. All right, I'm gonna put up on the screen the charge as it exists right now, and we'll work through it. Ms. Feely, Mr. Williams is welcome to stay in here for this. Have you two discussed about whether he wants to be here or not?
Doesn't have strong feelings, so.
I mean, it's not my decision, it's yours and his, so you talk about that. And Mr. Francis, you should talk about whether Mr. Tolbert wants to be here for the jury charge. He wants to be here. Here he will be. All right, on the screen should be the jury charge. I hope it's not teeny, but you have a hard copy as well. Let me see if I can magnify it a little bit. Be hard to because this is. It's alarming. All right, it's a little bigger. My approach is that I will flip through this until I get to an area where I had a question and discussion point. If I move past something for which any of the parties has a question or concern, let me know and we will rewind. So the first one was stipulations. And when I did this last night, so that's on page 3, there hadn't been any stipulations. I don't know that we need this. If you, I promise I'll come back to this, but you see the stipulations language. If we go all the way down to possession of a firearm by a convicted felon, I added a sentence that I borrowed from the last trial I had. You can see it's highlighted. The parties have stipulated that defendant is a convicted felon for purposes of counts 9 and 10. I think that's sufficient and addresses it, but I guess it technically doesn't say that a stipulation is something you have to accept. It worked in the last trial. Mr. Trepanier, tell me how you want to handle stipulation and the firearm counts.
I think the way it is, you have it, Your Honor, there is fine as long as it's got counts 4, 5, 9, and 10.
Okay. How's that?
You can't see it on this screen, Your Honor, but
What's happening on that screen?
it is just Judge McBurney's photo.
Oh, man. Okay. Sorry about that. Anyway, how about, can you log in with your computer?
I should be on. Yes.
Okay. Ms. Feely, does it work for you? And Mr. Francis?
Yeah.
Oh, no, but I meant, does this language work for you?
Yeah.
Okay, great. So I'll leave the stipulation language out. That gets us then to judicial notice. I didn't take.
Your Honor indicated that if we had moved past something to let you know.
Sure.
Grave suspicion, I know in the pattern does specifically say that it's unnecessary, according to Walther versus State.
What's unnecessary?
The grave suspicion charge,
What's the case?
Walther versus State. 196, appeals 721, and Lowe versus State 267, Georgia 180.
267, 180. So why is it in the pattern if it's unnecessary? And that wasn't a rhetorical question.
I believe because that is handled by the reasonable doubt presumption, the presumption of inference, burden of proof, reasonable doubt charge. So that charge takes care of it makes grave suspicion unnecessary because you're getting all that through the burden of proof.
I'm looking at low. Okay. Ms. Feely?
So what I'm hearing is it's been found in a case or two that it isn't necessary to give it, but that doesn't mean it's improper. It's well within the court's discretion. It is patterned. We did request it, and so we just renew our request.
Okay. Mr. Francis?
That's correct, Judge. It is not an error to give that charge. You have discretion, is my understanding.
Okay.
Give that charge if you see fit.
I'm going to leave it in, but I'm going to marinate on low and other cases for future. I'm a big fan of shorter jury charges, and that would take out 3 lines. They happen to be important lines, so I'm going to leave them in. But I'm going to see when it's not on your time what courts have done since low. Anything else before I get to judicial notice, Mr. Trepanier?
No, Judge.
All right. I don't think I should give judicial notice because I didn't take judicial notice of anything. Do you agree, State?
Agreed.
Ms. Feely? Mr. Francis?
Yes, Your Honor.
Okay. So there are a whole bunch of charges that relate to the statement of a defendant. They typically apply when we're playing the statement and there's a tussle over the Miranda waiver, et cetera. The party that would be in the strongest position to oppose the admission of the defendant's statement would be Mr. Tolbert and his lawyer. But there really wasn't any struggle over the admissibility of that. So I highlighted all this, not because they're problematic charges. It's that I don't know that they really apply given the unique facts and circumstances of this case. I'm going to start with you, Mr. Francis. If you want them, I need to give them. If you want a condensed version, we could come up with a condensed version, but all the language about the statement can't be induced by the slightest hope of benefit or remotest fear of injury. We never got into that level of examination with Detective Benton. And so I don't know how the jury would ever be able to tell. So what are your thoughts on that?
I don't request it.
Okay, Ms. Feely?
I'm fine with them coming out as well.
Mr. Trepanier?
Yes, agreed.
Okay. Identification. I think it's important to and proper to let the jurors know that the state has to prove the identity of the persons who committed the crimes, and I'll do this. And that the defendant doesn't have to show someone else did, but then all these other factors, there's not an eyewitness identification. I don't think they fit, and it's kind of surplusage for the jury. Do you agree, Mr. Trepanier?
Agreed.
So those first 2 sentences that you see on the screen, I intend to give, and then the rest I will omit. Ms. Feely?
That's fine.
Mr. Francis?
Agreed.
Okay. Fingerprints. There wasn't a lot of opposition to Mr. Lauzon's testimony. I still will give the basics, but sort of like with identification, I think it can be streamlined. No one challenged the validity of ACE V, or we didn't get into who lifted the prints. In fact, that person didn't testify. So I intend to give the first 2 sentences and then the paragraphs about circumstantial evidence and if it's based on fingerprint identification alone. Any issue with that, Mr. Trepanier?
No, Your Honor.
Ms. Feely? Mr. Francis? Okay. Presumptions and inferences is a charge that calls out for plain language improvement. But I also don't know that it fits with the facts of this case anyway. So I didn't try to wordsmith it. It was my suggestion that I not give it. Mr. Trepanier, what's the basis for giving it?
I think it has to do with a person's sound and mind discretion intends the natural and probable consequences of those acts, namely shooting somebody, the natural and probable consequence is the death of that individual. And so that's part of the reason why that would be requested.
Ms. Feely, any issue if I don't give that?
No.
Mr. Francis?
No,
Okay, I'm not going to give presumptions and inferences. Parties to crime, I omitted the final way in which one can be a party to a crime, the advising, procuring, et cetera. I think what you've got here is either someone directly committed it or intentionally helped in. Mr. Trepanier, any objection to that removal? I don't think there's any evidence that Mr. Tolbert, this is what you'd be arguing, Tolbert, not Williams, advised, encouraged, hired, counseled.
And Your Honor, the state is agreeable to the removal as suggested.
Okay, Ms. Feely,
Yes, Your Honor.
Mr. Francis.
okay.
Ms. Feely, I did get your recently submitted ones. Mr. Francis had already submitted them. They're on the screen right now, but presence and association are both included. I gave some, but not all of the conspiracy charges. There's an awkward short one, and then it's followed by what is in here.
As much as we can't stand that charge.
Yeah.
We have no choice.
We've already talked about the possession of firearm by a convicted felon. That was it for the areas where I had questions. So let me turn back to the state. Was there anything that you saw in here that we have not discussed that should be out, or anything not in that should be in, Mr. Trepanier?
I believe I had made one request regarding causation and felony murder.
So I don't know what version of the pattern charges you have, but we rewrote felony murder to plain language and it's all in there. I mean, I tweaked the language a little bit to make it even plainer, but I don't believe there is now a pattern on causation. It is what's in there. So you should look at what's on page 15 and let me know if that is somehow not sufficient. I'm happy to amend it.
Your Honor, I think as it reads on page 5 is appropriate.
Okay. Anything else?
No, Judge.
All right, Ms. Feely.
Yes, we object to the conspiracy jury charge. Conspiracy is not alleged in the indictment. I acknowledge that there is authority allowing the court to give it, and it's our position that it inserts a theory of liability that was not endorsed by the grand jury, so we are objecting to that charge.
Okay, but you are you're making a record that you object, but you are acknowledging that there is fairly ample case law that says it doesn't need to be charged for it to be given. Okay, you've preserved that. Mr. Francis, you've already mentioned you don't like the conspiracy charge. If you want to put a spin on that.
Same objection. It just appears to be, it gives the prosecutor another bite of the apple under these set of facts. You have parties they have 3 ways now to prove. They have directly commit, they have a party to the crime, and now conspiracy, where these facts indicate that the parties would be a party and it could be a conspiracy. And I think that's it's patently unfair to the defendant to have to defend against those 2 very similar issues. But I understand that's the state of the law, it is the state.
Okay, got it. I'll leave it in, but you've both preserved that for now, as an objection, but it'll stay in. Ms. Feely, anything else?
Yeah.
And Mr. Francis, did you have any, edits you wanted made to the jury charge?
No, I did not.
Okay, I generated verdict forms. I'll print those out and you can look at them in the morning. Obviously, one for Mr. Williams, one for Mr. Tolbert. The only difference is that Williams has all 10 and Tolbert has 6 of the 10 counts. I think that's the right number, but they're all in there. I double checked. So I think we're good for the day. We all should be back here a little before 9:30. If you're doing a PowerPoint, make sure it's set up and ready to go. If you're doing that direct connect thing, have that set up before we start. I'll have the camera running from behind the jurors, so you'll be what's on the screen if you don't have a PowerPoint. Anything else, Mr. Trepanier, from the state before we break for the day?
No, Your Honor.
Okay, Ms. Feely and Mr. Francis. Okay, Ms. Feely, you've got clothes for Mr. Williams for tomorrow and same for Mr. Tolbert. Okay, thank you, everyone.